Yeah, I was anticipating asking that very same question, so you beat me to it. Okay, so, well, let me ask you this. You have three more witnesses today, two today and one tomorrow?
We have one today and responded, Travers, I believe.
Oh, that's right. Oh, that's right. Oh, that's right.
And
So,
then we have one tomorrow.
okay, so there'll be two witnesses today and then one tomorrow, and then you'll be resting? Okay, very good. Let me just turn to the respondents and ask you what you anticipate.
We've been trying to talk amongst council as to who we can line up in this school vacation week.
Sure.
And what part of it is going to go first. We haven't lined it all up yet.
Okay,
We do anticipate that we will be trying to start up right after petitioner is through.
okay, so the petition will be done tomorrow. Do you anticipate calling any witnesses tomorrow?
It is conceivable. I have put out a subpoena for a couple of individuals.
Okay,
They may not get called at all, depending upon what happens today.
today, okay.
And
And,
I will let the petitioner know.
okay, well, that would be helpful to the petitioner to enable her to prepare her case. So like, Ms. Scarlett, like how many witnesses at most? You know, I don't anticipate you calling all of them, but if you want to, it's your call. But how many, what are we looking
I
at?
think I listed 7. The two that I subpoenaed, one of them was on the list, the other was not.
Okay,
The other individual was a clerk who was involved in this matter.
okay,
It may be unnecessary to call him.
okay,
Our witnesses include individuals who have knowledge of Mr. Early's involvement with the opioid matters. I know a petitioner doesn't think the case is about that. I'll probably reduce that by 1.
okay.
So the reality in my mind with respect to my case, 5 is, let me look at this for a minute. Yeah, and there is another witness who would be dealing with the opioid matter, who I have not discussed how to deal with this with petitioner. But I'm going to suggest that we deal with it by affidavit, and that may reduce the number further.
Okay, okay, very good.
So again, my max number, including myself, as a theoretical piece, is 5 is realistic.
Okay, and would they be in person, do you think, or would they be via Zoom?
I've informed them of the Zoom availability.
Okay.
And I expect at least one of those individuals.
We'll do Zoom. Oh, okay,
And I'll go over the names of the individuals and so forth with petitioner.
okay, very good. Ms. Burke, do you anticipate calling many witnesses?
Good morning, Judge. Yes. I'm not sure if it's a crossover with Mr. Conley's, but I have 2 of the members of the state police who are supervising authorities of my client.
Okay,
So one is likely to be on Zoom. I'm not sure if that's the same individuals we're talking about.
okay,
So I anticipate 3, possibly 4.
okay, 3 and 4, okay. And Ms. Bourgeois, other than Mr. Travers today, will you be calling anyone else?
I do not expect to call any other witnesses besides Mr. Travers, and just for informational purposes, I will be here tomorrow morning. I've got a flight out at 4:30 tomorrow. I will jump on the blue line, so
Okay,
I'll ask to be excused around 2:30.
okay, okay, very good. And Mr. Rusconi?
I anticipate having some crossover, I believe, with Attorney Burke. There'll be 2 members of the state police and Mr. McKeon, and I believe they'd be in close succession.
Okay,
I anticipate one would be, like as I said, we shouldn't anticipate, but I had communicated with the petitioner, I believe one would be on Zoom on Wednesday at the earliest, and that's the last communication I had with him.
okay,
The other one would be in person whenever December comes up, depending how things go.
okay, I would ask that, everybody just give that information to the petitioner so she'll be able to prepare her cross-examination. So I'd ask you to do it sooner than later, for obvious reasons. And I'd ask you maybe sometime today to start, letting us know the banning order, starting hopefully tomorrow, if not, then the day after. But I'd like to move this along as expeditiously as possible. Also, I want to ask the parties, and you don't have to give me an answer now, typically in ethics hearings, you have the option to do a closing argument before me or a closing arguments before my fellow 4 commissioners, so all 5 of us. I would assume you would prefer doing it before all 5 of them, but that's up to you, candidly. If it's before me, it would be sooner than later. And speaking to my fellow commissioners, they said they want to get the transcript, which will take a couple of weeks. They want to give you an opportunity to file whatever briefs you want to file for their consideration and then have argument. So we would be, talking about final argument, theoretically, subject to me hearing your thoughts. I got to guess about a month from now. It depends on how long you need to write memos, if you want to write memos. So, that's your call. And, I'll defer to what you want to do if it's feasible. Any preliminary thoughts on that?
Just for clarity, are you anticipating perhaps closes before you and then briefing and argument conceivably before the full panel?
No, it's an either or. So you wouldn't do a closing before May. So we would finish up whenever we finish up. And then I guess I would ask Ms. Duca to contact everybody as to how much time you would need to write a memo. If you want to write, it's not necessary. If you want to write a memo, that's fine. If you want to wait till you get the transcript, that's fine. It's really kind of your call.
My view I've done a lot of hearings.
Sure.
My view is I prefer to present my argument to the hearing officer.
Okay.
Now, this one candidly has been treated differently with everybody listening in, and I haven't thought about whether it would make more sense to do it the other way. But I will.
Okay. Do you have any initial thoughts? I won't hold you to it. Some initial thoughts.
I think the way you phrased it, it sounded as though you were Jedi mind game suggesting that we do it for the commission.
I'll do whatever you want to do, candidly.
What's your preference, Judge?
See, I'll be candid with you. I just don't care. But it just seems to me that the entire you argued your motion to dismiss before the whole commission. You argued your motion for summary decision before the whole commission. Now, this is the Super Bowl. It seems to me it's better for all the parties to argue before the commission. But if you want to argue before me and not waive and not argue before my fellow commissions, that's fine with me.
I'm zoomed out, so my preference is to have the bodies here.
Okay.
I mean, they're making the decision. I think they would appreciate seeing it.
Yeah, and I candidly, I anticipate it would be an in-person hearing if you want to. You don't have to be here in person. You can do it via Zoom, obviously, if you're not around. You can do it via Zoom. So do you anticipate writing a memo but you don't have to. It's your call.
I've said everything I want. I've said everything I want to say in about 3 preliminary
Right.
ways. So I don't know what else I can say. It's gonna
Okay.
change.
Okay, that's fair
But
enough.
I'll do whatever everybody else does.
Okay. Yeah, Ms. Bourgeois.
This may be a dumb question, but can we do it to you as the presiding officer and ask the commissions to listen to it?
Sure.
I might go that way just because the logistics will be a lot easier.
Sure. Yeah, so that that's fine. Ms. Rusconi, you have any thoughts?
Nothing that hasn't already been said. I think in general I prefer in person if we're gonna do the full panel, but I think I just want some more time to think on it.
Okay. Ms. Pruitt, you have with your thoughts?
Yes, I actually agree with Mr. Burke.
Excuse me?
Oh, my God.
But I have that right.
Make sure we have that transcribed correctly.
In part,
Okay, of course.
That we argue it before the full commission, but we would want to brief and argue it. So we want the transcript, we want to file a brief, we want to argue.
Okay, so it seems, it seems to me we should not bifurcate it. Two people arguing before me, and then the other two people arguing before the whole commission. If you argue before me, obviously we could do it as soon as next week, at the end of this hearing. If you argue before the whole commission, it's going to be realistically about a month, but it will be in person. So I'll just ask you to confer amongst yourself and then just let me know what you want to do, and whatever you want to do is fine with me.
On the
Okay.
record, I'd
Okay.
like to brief and argue it before the full commission, but I don't want to get away from tomorrow. Tomorrow, we expect to wrap up our case.
I understand.
We need to know who they're called. There are 4 respondents between the 4 of them, and over the past week, they knew they were gonna have put on their case. Who's being called tomorrow to testify?
Okay, well, that's fair enough. And what I suggest, after we call our first witness, I'll probably take a break, and then you folks can confer. And then after the second witness, you people can confer again. And at the end of today, we'll have hopefully a batting order
Thank you very
for
much.
tomorrow, in fairness to you, so you'll be able to prepare.
And it may end up that we start on Friday. Is that right? As I told you, I have 2 witnesses that are subpoenaed for tomorrow.
Okay.
But if I don't need them, we may be starting Friday morning instead of tomorrow afternoon.
Okay. All I'm asking you to do is just let the petitioner know what's going on, so she has adequate time to prepare. Okay. Okay, is that it?
One other thing, and as we indicated on Friday, we are prepared to introduce exhibits into the record, but we could do that after the testimony today.
That's fine. Thank you. Thank
Thank
you very
you.
much. Just, we had a commission hearing yesterday, and while we didn't really discuss the case at all, a few of my fellow commissioners brought it to my attention that because of the placement of the microphones, that, I think I already said that, they have picked up some conversations between you and your client, and they've also picked up they've also like paper rustling, and so for what it's worth, I note that to you, and to do with that as you wish. They asked me to pass that along to you, and I'm passing it along. So, Mr. Donald, you're standing up. I take it that you're,
Yes.
yeah.
Good morning, Presiding Officer Kantorowicz. The petitioner calls Brendan Keenan.
Hi, sir, how are you? Yeah, raise your right hand. How are you?
Hi, Brendan Keegan.
Yeah, could you raise your right hand? Swear to tell the truth, the whole truth, so help you God?
I do.
Okay, thank you, sir, and thank you for coming in today.
Judge Kantorowicz, may I please the commission, Daniel Sullivan.
Oh.
On behalf of the trial court, we're
Okay, and anytime if you need to consult, just let me know.
Thank you very
I
much.
don't think that's going to be a problem, but if it is, you want to consult with your lawyer, just let me know. If you think he needs to consult with you, just let me know, and I'll take a break to allow that. Okay, thank you, Mr. Sullivan. Okay. Donald?
Morning, may I inquire? Please. Please state your name for the record and spell your last name.
Brendan Keenan, Keenan.
And Mr. Keenan, are you appearing here today because you received a subpoena?
Correct.
And you're represented by an attorney, is that correct?
Correct.
And your attorney is present here today?
Yes.
And that's attorney Daniel Sullivan from the trial court.
Yes.
Are you currently employed?
Retired
Congratulations.
Thank you.
When did you retire?
December 28th of 2021.
And prior to your retirement, where were you most recently employed?
In the Orange District Court,
And what position did you hold in the Orange District Court?
First Assistant Clerk Magistrate,
And how long were you employed with the Orange District Court?
just shy of 2 years.
Prior to working in the Orange District Court, were you employed?
Yes.
And where were you employed prior to working in the Orange District Court?
With the division of the District Court,
And could you describe what positions you held in the Worcester District Court, please?
I started in 1974 at the entry-level position. And during that time, between then and 1986, I became a assistant clerk. But in the meantime, I became a sessions clerk and bail commissioner, and then the assistant clerk in '86. And then about 5 years later, I became the first assistant clerk. And in July of 2017, I became the acting clerk magistrate. No, 2017, the acting clerk magistrate, until February when I went to Orange of 2020.
So how many years in total did you work in the Worcester District Court?
Roughly 45,
And how many years in total have you worked for the trial court?
47.
How busy is the Worcester District Court?
When I was there, it would be the second busiest in the Commonwealth.
Second busiest court.
There was always an argument between Worcester and Springfield. I would say we were the second.
Directing your attention to October of 2017, you were employed in the Worcester District Court during that period of time, is that correct?
Yes.
Okay. Are you familiar with the process that the Massachusetts State Police used at that time to apply for a criminal complaint when there was an arrest?
Yes.
Who would file the application for a criminal complaint
A
for the
court,
Massachusetts State Police?
a court officer from the barracks.
I'm fine, you can continue.
And who was the Massachusetts State Police court officer that covered the Worcester District Court?
Troopergate.
And what paperwork would Trooper Ricciardi present to the clerk's office when he was coming down to apply for a criminal complaint?
You bring a copy of the application with the charges and defendant identifying information on it, the charges, the statement of facts, and the police report that we refer to as a statement of facts.
Do different police departments include different information when they bring down the applications for criminal complaints?
Yes, that's why I hesitated a little bit there.
What information would, say, the Worcester Police Department typically bring?
They would have a statement of facts. They wouldn't just copy and paste the whole report, because if we were so busy, it would take too long to go through all the reports. Find probable cause, it wasn't necessary.
And what would the Massachusetts State Police typically include?
The whole police report.
All right, for a state police arrest, who would review the application and the arrest report?
One of the clerk magistrates, either assistant clerk or myself, whoever would be first available.
And why does the clerk review the application and the arrest report?
To ensure there was a probable cause for the arrest.
And what is probable cause?
The statement would be based on if a crime was committed and if the defendant committed a crime. We would look to see all the elements of the crime and make the elements in the report to make sure they fit the charges.
If I could ask legal advisor Duker, we would request the witness be given stipulated exhibit number 4, which is the criminal complaint application and arrest report involving the judge's daughter.
Thank you.
Mr. Keenan, if you could just review those documents, and then when you're done reviewing them, please look up again. Do you recognize what has been marked as stipulated exhibit number 4?
Yes.
What do you recognize it as?
The criminal complaint complaint application.
Is that the criminal complaint application for the judge's daughter?
Yes.
I direct your attention to the middle right.
Just, I'm gonna object to it being referred to as the judge's daughter. It's not the judge's daughter's arrest.
Okay.
It is Ms. Bebo's arrest.
Okay, so perhaps you can clarify that.
I might.
Or just use- just use-
Try not to use the individual's name.
I think that horse was left
Okay.
his barn a week ago, so.
No problem. Is that, Mr. Keenan, is that the criminal complaint application and arrest report for Ali Bebo?
Yes.
And if I could call your attention to the middle of the top page where it says case information, the lower right corner of the middle, do you see a date there?
Yes.
And what's the date you see there?
Looks like 10/16/17.
All right. And how many total charges did the Mass State Police apply for in the application? For criminal charges against Ali Bebo, the judge's daughter.
5.
Okay, and that's 3 charges on the first page, and I saw you flip over, there are 2 charges on the second page.
Yes.
Drawing your attention to the bottom of the document where it says complaint issue. You see a box with the date,
Yes.
and what's the date that you see there?
10/17/17.
And would that be the day after Ali Bebo was arrested?
Yes.
And I call your attention to the box on the lower right where it says clerk judge. You see some initials in that box?
Yes.
You recognize those initials?
Yes.
What are the initials that you recognize?
PJ.
And do you know who PJ is?
Yes.
Who's PJ?
Paul Johnson.
Does that mean that Paul Johnson was the clerk who found probable cause to issue the criminal complaint against Ali Bebo?
Yes.
And do you know Paul Johnson?
Yes.
Where does he work?
In the Central District Court, Worcester.
And that's the same office where you work?
Yes.
Okay. Turning your attention to the middle area, right under where it says complaint issued. What does it mean that probable cause found for the above offenses, the box is checked? What does that mean?
Means on count 3, the negligent operation of a motor vehicle, probable cause was found on the facts set forth in the attached statement.
Would it also mean, because the clerk checked box 3, that it also applied to counts 1 and 2 in that situation?
1 and 2 would be civil motor vehicle infractions, and it's not a probable cause determination.
Okay.
And they normally just go along with the criminal.
So the clerk just found probable cause as to the criminal
Criminal
offense.
complaint.
Okay. And you see the box underneath there next to facts set forth and attached statements?
Yes.
And that box is checked, right?
Yes.
And what does that mean?
There was an attached statement with the application, and Mr. Johnson reviewed that. He found probable cause based on that statement.
Okay, and what was the attached statement?
It appeared to be the police report.
And do you have that document in the package you're reviewing there?
Yes.
And what does it say in the top of the document if you flip through the second or third page of the report? What does it say in the top?
Arrest report, Holden State Police. State Police Holden.
So on what did Paul Johnson base his findings of probable cause?
Objection, Judge, that calls for a conclusion as the state of mind of another witness.
Yeah, I'm not, yeah, that's a stake.
What was the attached statement to the application then?
Would you repeat that, please?
In box on the first page, you testified,
Yeah.
facts set forth and attached statement was checked, is that right?
Yes.
And what was the attached statement?
It would have been the paperwork that the state police gave Paul Johnson that morning. And I believe it was the entire police report.
Okay, and that's the police report that you have in your hands.
Yes.
If I could direct your attention to the second page of the application. Again, in the lower left corner, you see that 10/17/17 date again, is that right?
Yes.
And are those the same initials for Paul Johnson, in the lower right corner where it says clerk?
Yes.
And what did he check for probable cause found for above offenses?
You checked off box 1 and 2.
Okay, and what charges would those boxes refer to?
OUI drugs and OUI liquor.
And what did he check off as far as the probable cause was based on facts set forth and attached statements? Did he check that box?
Yes.
And again, that would be based on the arrest report that was included. Did you answer? I'm sorry.
Yes. Yeah.
Okay, thank you, sorry. All right, after Paul Johnson found probable cause, what happened next? What would have happened next in the process?
The application and the attached statement would go out to the main office, and one of the staff members would enter all the information into Mass Courts and generate the complaint.
And what would have happened with the complaint at that point?
The complaint would have go up to the arraignment session.
And when would that criminal complaint have issued? What date?
Oh, the 17th.
Is that October 17th,
October
2017? All right. When was the next time that you were involved in this matter? After that October 17th, 2017 complaint issue?
After this, my involvement would be to tell one of the staff, make sure Judge Despotopoulos sees this. Because the rule that if there's a appearance of conflict in a division, if somebody is a victim or a defendant or anything, if they have a tie, close tie to the division, I would point that out to the judge.
And other than that, what's the next time you remember being involved with this matter?
Next time would be 3 days later or 4 on that Friday afternoon,
Okay. Do you remember the date?
October 20th.
Friday afternoon, October 20th, 2017?
Yes.
Okay. And what happened on Friday, October 20th, 2017?
I met with ADA Travers
And where did you meet with ADA Travers?
in my office, my office, not the clerk's office, my office.
And do you know Jeff Travers?
Yes,
How do you know him?
he's a professional colleague, you know.
And what did Jeff Travers say when he met with you in his office?
I don't remember the exact words, but I remember the, basically, the goal was to try to remove some statements that were, he was saying salacious, and they have no bearing on the probable cause that was found, and the publicity would be horrible, without publicity.
And what did Jeff Travers want to do?
To have, he had a report, I believe, I'm not sure, that he wanted to replace with the report that I had.
So he wanted to replace a report that he had with the report that you had. Is that what your testimony is?
Objection, leading.
Well, that's overruled, but we are getting to the important testimony, so watch the leading questions, okay?
Can I just have the question read back to him? I don't think he answered it.
So he wanted to replace a report that he had with the report that you had? Is that what your testimony is?
Yes,
And what did you say to Mr. Travers?
I can't do that,
And why did you tell Mr. Travers that he couldn't do that?
because the statement that I had was the statement that the probable cause was found, you know, was on the record, and it's the record of the proceeding.
And after you told Mr. Travers that he couldn't replace the arrest report, what happened next?
We had a
Judge,
conversation.
I'm gonna object again. He didn't say he couldn't replace it. He said his quote was, I couldn't do that.
I couldn't do it.
Yeah, there's a difference.
Okay, well, what's the next question?
My next question was essentially what happened next after you had the conversation with Mr. Travers?
We talked further about if there was any way to accomplish the what his goal, I shouldn't say, what he wanted to happen. You know, somehow we came up with the idea of redacting the original report and to redact the lines, to cross out the lines that he was talking about being salacious and prejudicial to the case.
So did you and Mr. Travers go anywhere after your conversation in your office?
I went, yes, Judge Travers went out to the hallway. I told him to go upstairs up to the courtroom 14, and I went up to the courtroom. I went up to the judge's lobby.
Okay, and who are you going to see in the judge's lobby?
Despotopoulos.
And who is Judge Despotopoulos?
He's the first justice of the Worcester Division.
And why were you going to see Judge Despotopoulos?
I wanted to let him know what Judge Travers, ADA Travers' intentions were.
And just so I'm clear, where was Mr. Travers when you were going up to see Judge Despotopoulos? Where was he physically?
I'm not sure. I sent him out into the main lobby, and I asked him to go outside the judge's
Okay.
lobby.
And who did you see when you went up to see Judge Despotopoulos?
I saw the DA and Judge Despotopoulos.
Is that District Attorney Early?
Yes.
And you also saw Judge Despotopoulos?
Yes.
And where were they? Could you describe where DA Early and Judge Despotopoulos were?
They were like I don't know, it'd be like a foyer in the judge's lobby, like an open area.
And what were Judge Despotopoulos and District Attorney Early doing?
I'm not sure what they were doing, but they had their phones out, like they were scheduling a meeting.
And at some point, what did you do next?
I stepped back until the conversation was done, and when I saw him finishing up, I walked up to both of them. I told Judge, I said, Your Honor, the ADA Travers was down in my office, and he wanted to change a report. And I told him we couldn't do that, or I couldn't do that. I'm not quite sure how I said it. And he wants to see if you'd entertain an oral motion to have the original report redacted.
And how far away was District Attorney Early when this conversation took place?
In close proximity.
Did District Attorney Early say anything?
Yes.
And what did District Attorney Early say?
Oh, you can't do that.
And what did you respond when District Attorney Early said, oh, we can't do that?
Either I or the judge said, no, we can't do that.
And do you remember if you responded to District Attorney Early?
I think I did. I think I said, no, I can't do that.
Okay, and why couldn't you do that?
Because the original report is the record.
And did District Attorney Early say anything in response to you saying that you can't do that?
He said, I'll leave it in Jeff's hands. Something to that effect.
And
Sorry,
what
can I
did,
have that? I'm sorry, can I get it again? I didn't hear it all.
He said, oh, I'll leave it in Jeff's hands.
and what did Judge Despotopoulos say?
I'm not sure if he said we can't do that or not, but that was it, just.
And did District Attorney Early, was he there and heard when Judge Despotopoulos said that that couldn't be done?
I believe so.
What did you do after the conversation that took place with Judge Despotopoulos and District Attorney Early?
District Attorney Early left, and you went out into the main area, wherever it is, out in the hallway. And I asked the judge, you want to bring in ADA Travers? Then I went and I got ADA Travers into the judge's lobby.
So ADA Travers came up to the judge's lobby, is that right?
He was outside. I asked him to go outside.
And were you still there at that point?
Yes, I went out and I got ADA Travers and I brought him into the lobby.
So it would be Judge Despotopoulos, you, and ADA Travers at that point?
Correct.
And what was said by ADA Travers at that point?
He was explaining, well, he was telling the judge that his intention would be to file a motion or a motion to redact the statements that would cause too much pre-trial publicity. And he would wonder if he could entertain that oral motion.
And what did Judge Despotopoulos say?
I'll hear you on the record.
What happened next?
Next, I brought Judge ADA Travers out to the main area again. I said, why don't you get back down to the clerk's office I went back to the judge's lobby, I went down our elevator to my office, and I hooked up with 88 Travers again, went back to my office.
And what did ADA Travers do at that point?
More like
What did you do at that point?
Yeah.
I'll start with you.
I took the original report and I made a copy of it out in the office.
And what did you do then?
I brought it back and I handed the copy to Travers and I gave him a black marker.
And what did ADA Travers do?
He was marking off lines.
When you say marking off lines, what do you mean by that?
He had the paper that I gave him. He was sitting across from my desk and saw him going like that.
Okay. And do you know what statements that ADA Travers marked off?
Didn't look, I didn't ask.
If I could have you take a look at stipulated exhibit number 4 again. And if you could go 5 pages in, please. Take a look at pages 5 and 6. There are some black lines on page 5 and
Yes.
page 5, 6.
Yes.
And what does it say on the top of page 5 as far as the document?
Arrest report, state police holding.
And what does it say on the top of page 6?
Arrest report, state police holding.
All right, thank you. Prior to October 2017, are you aware of anyone in the district attorney's office asking to redact an arrest report to remove statements made by an arrestee?
I don't recall.
Prior to
Can you repeat
October,
that again? I'm sorry.
yep, sure. Prior to October 2017, are you aware of anyone in the district attorney's office asking to redact an arrest report to remove statements that were made by the arrestee?
I don't recall.
Prior to October 2017, are you aware of anyone in the district attorney's office asking to redact an arrest report to remove sexually explicit statements made by an arrestee?
I don't recall.
How many times had Jeffrey Travers come to see you about a criminal case prior to October 20th, 2017?
That's very difficult to answer because I don't know. I don't recall any particular ones, but I know I would see 88 Travers.
And after October 20th, 2017, how many times did Mr. Travers come to see you about a criminal case?
No.
Prior to October 20th, 2017, had ADA, First Assistant ADA Travers ever discussed redacting an arrest report with you?
I do not recall any.
After October 20th, 2017, how many times did Travers discuss redacting an arrest report with you?
After, never.
Mr. Keenan, why did you tell Jeff Travers that he couldn't replace the arrest report on file with the court with a revised arrest report?
Objection, that's not the state of the testimony.
Well, if he can answer it, he can, that's overruled.
Could you repeat that?
Can I just have the court reporter read that back, please?
Mr. Keenan, why did you tell Jeff Travers that he couldn't replace the arrest report on file with the court with a revised arrest report?
I thought he wanted me to just take it and swap it. You know, I couldn't do that. You know, it's a record. The one I had was a record.
May I have a moment, Presiding Officer Cantwitz?
Take your time.
Mr. Keane, as far as all of your interactions involving Jeffrey Travers in this matter, can you give us an estimate of how much total time you spent dealing with this situation?
Objection.
That's overruled.
May I be heard?
Sure.
This relates in part to a stipulation that I believe was reached with the respondent, and it is Travers stipulation number 3. And it states, quote, "The order to show cause against respondent Travers does not allege any violation of chapter 268A with respect to events occurring after the conversation between he and Clerk Keenan on October 20. Therefore, if where they're going, if there's no claim of wrongdoing against Mr. Travers for anything after the initial conversation. Therefore, the time spent with the judge, the time spent during the redaction is not part of their case. They don't claim that Mr. Travers did anything wrong in doing the redactions with the judge's approval. Question's not relevant.
Okay, well, he can have the question. That's overruled.
Thank you. So how much total time did you spend with your involvement in this matter involving Mr. Travers?
Maybe 15 minutes downstairs, 10, 15 downstairs, and probably 25.
Additional 25?
Yeah, no, altogether 25 minutes.
25 minutes. And, do you recall what your salary was in 2017 approximately?
Objection. What's the relevance of that?
Well, they brought in, they wanted,
I'll withdraw.
okay, yeah.
In 2017, we were going through a series of pay raises, so I don't know exactly, but I could, maybe 140, somewhere around there.
$140,000 approximately.
Yeah, because there were a bunch of step raises that were taking effect.
Thank you. I don't have any further questions for Mr. Keenan.
Thank you. Since you're standing up, I take it you're gonna be the first to examine.
I'll just do one go to the sequence, Judge. I don't.
Yeah, it makes no difference to me.
Do you want to go first? I will. All right.
Okay, Mr. Burke.
He's heading towards the podium.
Okay.
Good morning, sir.
Good morning.
I'm Attorney Tim Burke. Have we ever met before?
I'm not sure if we met at the barracks one time.
Okay.
Oh, no, Framingham.
You have a better memory than I
Yeah,
do.
it would have been many, many, many years ago.
Let's not go into that. Do you know my client, Major Sue Anderson? Could you just stand? Major?
Yes, I know.
Okay. She did not participate in anything that took place at the courthouse, to your knowledge, did she?
No, not that I know of.
Okay. And amazingly, you've worked for 47 years in the Worcester District Court and the Orange District Courts? Okay. See a lot of cases come through? Would you estimate tens of thousands of cases?
Yes.
And you obviously have had experience with what probable cause consists of, as you indicated before. And have you, since this case came about, have you gone back and looked at the contents of that police report?
No.
Okay. Do you, so you wouldn't be able to say whether or not in the very first 2 paragraphs of that police report that was submitted, if probable cause existed in just those 2 paragraphs combined? Could you say that?
No.
Okay, in any event, as I understand it, at some juncture, the police report is processed, the application for the complaint is issued, right?
Yes.
Okay, and you don't participate in that, right?
Right.
That's Assistant Clerk Johnson?
Right.
Then it goes to the arraignment session, right?
Correct.
And for those of us who aren't familiar with arraignments, that's when the person is brought in and formally notified of the charges that are brought against them, right?
Correct.
And would you agree with me that the very charges that, you said there were 5 initial charges, right?
Correct.
And those 5 charges were the product or based upon the probable cause that appeared in that police report, right?
Yes,
And would you also agree with me that about 3 months later, Ms. Debo admitted to sufficient facts to all 5 of those charges? Did you know that?
I knew the case was disposed of. I don't know how.
All right. Well, in any event, whether you knew that or not, at some point in time, did you learn that there had been a motion filed, not by Jeff Travers or anybody else, but by Ms. Debo's defense attorney, because she had read that police report and found that there is the potential for pretrial publicity based upon the salacious nature of the contents of that report?
Yes,
You read that report, you would agree that those were salacious comments that were included within the body of that report, wouldn't you?
yes.
Terrible comments, right?
It was salacious, yes.
Yes. And you said that probable cause had already been established, right?
Yes,
And there's a motion that's filed, again, not by the DA's office, but by her defense attorney, right?
yes,
And you deal with defense attorneys every day, don't you?
yes,
And you would agree with me that the defense attorney, if had the right, if not the obligation, to file that motion to impound based upon her perception of what was concluded in that report, didn't she?
attorneys can file whatever motion they feel appropriate.
Okay. And that's what was done in this case, right?
I believe so.
Well, I mean, you know that that police report was impounded, right?
Yes, yep.
Okay. And that was done, that wasn't done by you, was it? You can't do that. You don't have the authority to issue an impoundment order, do you, as the clerk?
No.
And the person or the entity that has the authority to do that is a judge, right?
Yes,
Yeah, you said your first busiest court in Massachusetts, right? Forget Springfield. All right, so how many judges do you have sitting there?
well, could be 6 or 7 a day
Okay.
when I was there.
And you hadn't spoken to the judge who issued that impoundment order before it issued, did you?
No.
Okay, so just so we're getting this lined up. Arrest report's given to the defense attorney, right?
Yes,
That's part of the process. Nothing different or unusual about that. Happens every single day, doesn't it?
yes,
Defense attorney reads it, says, what is this doing in here? And she files a motion to impound, right?
yes.
Okay, you know this, right? You know that she filed a motion to.
Oh, I know she did, yes.
Okay.
Yeah.
And that's heard, not in somebody's chambers or in some back room, it's heard in open court, isn't it?
Yes.
Okay, and just for everybody's edification, what does impoundment mean? What does it do when a judge impounds a document?
The matter that is impounded is kept from public inspection.
Right,
It is.
public doesn't have access to it,
Yes,
right?
right.
And a judge has to have a legitimate reason to do that, don't they?
Good cause.
Good cause, all right? And you've seen judges order impoundment of documents frequently, haven't you? Maybe not every day, but it's not an unusual occurrence for a judge to impound a document,
Yeah, I've seen it.
okay? And are there specific rules in which a person has to establish before a judge can order the impoundment of a document? Okay, so when this comes to you, so that was on the 17th of October, right?
Yes.
That's when the impoundment takes place. And then 3 days later, you have your interaction with Assistant District Attorney Jeff Travers, right?
Right.
Okay. So all this, for this 3 days, it's been impounded, right?
Right.
And as part of the impoundment order, you have to notify, whether the clerk or somebody has to notify the person who was like the state police in this case, that the document that's been presented by the court officer has been impounded. Do they have to be given notice of that?
Yes.
Okay. Do you know if that took place?
I reviewed the arraignment tape and I heard the VA ask the defense attorney to serve that on the state police.
Okay, so it's not like it just happens in a vacuum, we impound it, nothing else happens after that, right? Under the rules, the impoundment rules, and Rule 8 is it?
There's a number, yeah, there's a number of rules, but I think you're referring to Rule 8.
Yeah, all right, I wasn't sure, but it's
Yeah.
Rule 8?
Yeah.
All right, so as a condition of that, once it's impounded, the ADA has to notify the state police, got an issue here, right?
Mhm.
That means yes.
Yes, yes, I apologize, yes.
Okay, all right. And so when that happens, the state police are notified by order of the court, right? Okay. So then, did you know as to whether or not there was any revisions that had already been made in terms of what you described as the salacious content of that document before it came to you?
No,
Okay, so you don't know what actions the state police took to revise those statements that were in there that were salacious before it came to you, do you?
no, I don't.
Okay. So in any event, have you read the Attorney General's report that there was nothing done by those revisions that in any way altered the existence of probable cause? Did you know that?
I read the Attorney General's finding. I don't recall that part of it. I remember, I read it.
Okay. So this case wasn't just dismissed or anything like that, was it?
No, right, it wasn't.
Went through the normal process that any OUI, whether it's under the influence of alcohol or drugs, would have gone through, other than the removal of 3 statements that were deemed to be potentially prejudicial. Isn't that true?
Yes.
And when Mr. Travers spoke to you, I was listening to you, and you said he brought this to you asking a question, right?
Yes.
As to what the process was regarding the potential.
I don't believe that was a testimony.
Well,
Well, you can ask a question and the witness can respond and clarify.
when he comes to you, he's asking you for direction and guidance. Didn't you sense that?
I sense that he wasn't saying, take this. You know, I can't quite recall the specific words.
You can't remember exactly what happened 5 years ago? Mr. Keenan, did you get the sense, you know Jeff Travers, did you get the sense that he was looking for your direction or your guidance in this?
Yes.
And what you said, I can't do this. You do not have the authority to change that, do you?
I don't.
Okay, does the judge have the authority to approve the redaction of that based upon your 47 years of experience?
I believe so.
Okay, and that's what happened here too, isn't it?
Yes.
Went before a judge after it was impounded, presented to a judge in open court.
Yes.
There's a transcript available, there's a tape recorder running.
Yes.
People can come in and out regardless. There's nothing done in the chambers. It's out in open court, right?
Correct.
There's a record made of it.
Yes.
You then have to make that documentation to your office, has to make a documentation as to what took place in that hearing, right?
Yes.
So there's a public record of that.
Yes.
Okay, and then once those 3 salacious statements or prejudicial statements are removed, is that put back in the public specter?
Yes.
They have access to it?
Yes.
You never spoke to Sue Anderson, did you?
No.
Thanks.
Okay, thank you. Do you want to go, Mr. Kiley, or do you want
It's
to?
not my witness. It's not my witness. It's Meredith's witness.
Okay. Okay.
Would I ask to see and then show to the witness exhibit number 2, please.
Sure. Can I have that
He's
back?
gonna need that too, so.
He'll need that? Okay, once you sold that, and you need exhibit number 2, Mr. Bourgeois?
Yes, sir.
Okay, here you go.
Thank you.
Thank you.
And can I take a look at that also? Thank you. Good morning, Mr. Keenan.
Good morning.
You and I haven't met before, have we?
No,
Although it's been 47 years for me, I wish there was. And I'm close to retiring too. I asked to show you exhibit number 2, and it's the revised report that you've heard so much about. And I'll start with a simple question. Have you ever seen that document before?
I don't recall the front page.
Look at page number 2,
Yes.
and particularly the narrative of arrest section. Have you ever seen that document before?
No.
Okay, so just to make clear, in all of your conversations with Jeff Travers, in all of your interviews with the Attorney General's office, and all of your interviews with the petitioner's office, nobody ever showed you that document, right?
Right.
Okay. And your conversation with Jeff Travers about that document never progressed to the point where he handed you the document or gave it to you. That conversation was pretty short, right? Now, looking at the page 2, do you agree with me, sir, that under the arrest narrative, it says in capital letters, revised on October 19, 2017.
Yes.
Somebody typed that in capital letters in the section, correct?
Correct.
You agree with me that anyone who looked at that document would know exactly what section was revised and when it was revised?
They would know, it says revised, like, I wouldn't know what sections are revised.
Well, the capital is in the section entitled arrest narrative, right?
Yes.
Okay, so you would know that it was the arrest narrative that was revised.
Yes.
And also looking at it, you would know because of the date that is on exhibit number 4, that the revision was 2 days after the probable cause finding, right?
Right.
Okay, so would you agree with me that there's no way that exhibit number 2 could get passed off as the original material in support of probable cause?
Right.
Would you agree with me that it's conspicuous that it was changed afterwards, right?
Yes.
Okay. And Mr. Travers didn't ask you to backdate any documents, did he?
No.
Didn't ask you to change the date of the finding of probable cause, right?
No, you didn't.
He just asked you if you could accept the document, right?
Yes.
And you said, I can't do that, right? Now, I think I'm done with those. You talked about how busy the Worcester District Court is. And part of that busyness is that frequently motions are handwritten, correct?
Yes.
And in this case, the motion to impound made by the defense attorney for Ms. Bebo, that was handwritten, correct?
Yes.
And that's not an odd occurrence in your court, is it?
No, it's not odd.
And it's not an odd occurrence for somebody to make an oral motion instead of a written motion, correct?
Correct. More odd, but still
Right.
it happens.
And it's not odd for someone to ask you whether something can be done without a motion at all, without bothering the judge, right?
Yes.
In fact, sometimes, isn't it true that part of your job is to make sure the judges get bothered with things that they need to get bothered with and don't get bothered by things that don't need their attention, right?
Yes.
And so you don't think there's anything odd or amiss when a lawyer asks you if something can be done? That happens to you frequently, right?
Correct.
And sometimes you say yes and sometimes you say no, right?
Right.
And when you have to say no, you don't automatically assume that the lawyer asking you to do something is asking for something dishonest or unethical or corrupt, do you?
No.
It's just, he's asking a question, he's getting an answer, right?
Correct.
And when you gave Jeff Travers the answer that you couldn't accept the document, did he argue with you?
No.
Did he push back?
No.
Insist, you gotta take it.
No.
He just said, okay, and then the conversation moved on to discuss ways of avoiding the publicity, right?
Correct.
And you, in response to a question on direct examination, referred to, used the phrase horrible publicity, right?
If I, yeah,
And you agree that those statements, because it was the daughter of a judge who was head of a drug court, gave rise to the possibility of horrible publicity, right?
if I may, it would have been horrible also, for any family.
It would have been,
Yeah.
it would have been awful for any family to read that about a child, right? And you don't disagree with that, right?
No.
And it's the kind of story the newspapers would grab onto, wasn't it, right? In your deposition, in response to one of the questions, I think it was number 7. I'll just read it to you if I can. You tell me if I'm reading it correctly. You wrote, and I'm quoting now, "I recall that on October 20, 2017, ADA Travers came to my office and asked for guidance on amending an arrest report that had already been submitted to the court." That's what you said then, is that right?
Yes,
And that's what happened, that he came to you for guidance looking as to what he should do with that report, correct?
Right.
And he asked you if you could take it, correct?
Right.
You said no, and then you proceeded to give him guidance as to other ways that the problem of publicity could be solved, right?
yes,
And giving that kind of guidance is part of your job, right?
yes,
You've been doing it for 45 years, correct?
correct.
And at that time, you understood that Judge Locke had already impounded the document. Is that right?
Correct.
And again, in your deposition, you stated that I could find it just a second. Question number 8. I'm quoting now, immediately prior to my interaction with ADA Jeffrey Travers on October 20, 2017, I do not recall being aware of an expiration date for the order of impoundment. You remember writing that?
Yes.
And as far as you're concerned, Mr. Travers had the same feeling or the same understanding that there was no expiration date on Judge Locke's order. Is that right?
I don't know what ADA Travis thought
But what you thought at that time was there
At
was
that
no
time,
expiration date.
at that
right?
time, right?
Right, at that time. And now we've heard testimony in this case. I don't know if you heard Judge Dolly say that he thought it was 10 days, correct?
I reviewed the arraignment
Okay.
since then.
Yeah.
And I
And-
reviewed the impoundment.
All right, did you listen to Judge Locke's tape?
Yes,
Okay, and he said in that tape that it would be continued until the next court appearance, correct?
correct.
So between no expiration date, which is what you thought, next arraignment date, which is what he said, and 10 days, which is what Judge Dolly said, you'll agree with me that there was some confusion about when this letter expired, right? And you agree with me that as a matter of professionalism, because the file was gonna go to another court, it would be better to get that question resolved, right?
Yes,
And in a way, it got resolved, because at the end of the day, when you and Judge Travers, you and Mr. Travers and Judge Despotopoulos were all done, the impoundment order was lifted, is that right?
Correct.
And at that point, there was actually more public information available than there was at the beginning of the day, right?
correct.
Because the entire probable cause statement had been impounded before, but only 3 sections of it were redacted at the end, right?
Right.
Isn't it true that the idea to redact, that was your idea?
I don't remember it, but I wouldn't be surprised.
Yeah, okay. Couple of questions just about, okay, is your understanding that the redactions that were done, the 3, those were done under the procedure and approval of Judge Despotopoulos, is that right?
Correct.
And I just want to clarify something because it might be confusing. You talked with Mr. Travers, then you left him alone and you went to see Judge Despotopoulos, right?
Yes, I had Jeff go upstairs, Jeff Travers go upstairs to the judge's lobby on the outside public area to wait till I got him.
And when you got to see Judge Despotopoulos, the district attorney, Mr. Early, was there?
Yes,
Was it your understanding he was there in an unrelated matter?
yes,
Okay, in other words, they weren't talking about.
not that I heard, no.
Right. And then what happened was you spoke to Judge Despotopoulos about Mr. Travers' conversation, correct?
Right.
And Mr. Travers was not there during the conversation that you related on your direct exam, right?
Right, he wasn't.
And then Mr. Early said, I'll leave it to Jeff, meaning Jeff Travers, right?
Right.
And then you went back to Jeff Travers and the redaction, right?
Yes.
You talked on direct examination about the different ways that police departments handle arrest reports and probable cause statements, correct?
Correct.
And do you agree with me that some police departments import the entire arrest report into the probable cause statement?
Correct.
Some just boil it down to what's sometimes called the gist of the report, to a smaller statement, and that's what's used, is that right?
Correct.
And would you agree with me that the larger putting everything in the probable cause statement creates, I wouldn't say difficulty, but it takes more time for your office to kind of sift through the whole report to find the elements of probable cause for each of the offenses?
Correct.
You actually prefer the shorter statement, right?
Correct.
In fact, you came up with an idea for a procedure, didn't you, of when the police use the big report and it's all there, asking them to highlight the elements that they relied upon for probable cause, right?
Correct.
Because that made things a whole lot simpler, correct?
Oh, we would still have to look at the whole thing because they could have a name of a sexual assault victim in there. You know, we still have to look through it, but it would help a great deal.
Okay. Now, regardless, I guess more globally, considering that there are different ways that police departments do it, do you agree with me that the question of how much detail should go into a probable cause report is a subject on which reasonable professionals can differ? Right?
Yes.
someone can be honest and sincere and say, it all goes in there, right?
Mm.
And someone can be honest and sincere and say, no, it doesn't all belong in there, just the elements that relate to the crime charge, correct?
Correct.
And you can make that position without being dishonest or corrupt or trying to do anyone a favor, correct?
Correct.
Now, 47 years in the courts, right?
Correct.
And in truth, you're not a lawyer, right?
No.
But you are in every way an officer of the court, right?
Correct.
And you take your reputation and you take the reputation of your court seriously, don't you?
Very.
Very seriously, right? And you know the difference, don't you, between somebody who's asking you a question, can we do something? And somebody who's advocating for a dishonest or an unethical or a corrupt course of conduct. You know that there's a line between those two, don't you?
Yes.
And isn't it true that at no time did you believe or think that my client, Jeff Travers, crossed that line?
I did not believe that.
Thank you, sir. That's all I have.
Can I just ask you to just stay at the podium for a minute? Because as I've indicated a few days ago, some of my fellow commissioners are listening in and they have questions which they send to Ms. Duca and she hands me it. So I'm just going to ask the questions that, and you may have some follow-up questions as a result of the questions that have been asked. So the first one, sir, did you know of the impoundment when Mr. Travis came to you?
Yes.
Okay. Did you discuss the impoundment with Mr. Travers?
Not that I remember.
Okay. Okay, and the next question, why proceed with replacement or redaction if the document is impounded? If you have an opinion on that, if you can answer that, why proceed with replacement or redaction if the document is impounded?
Would you repeat again?
Sure. Why proceed with replacement or redaction if the document is impounded?
The impoundment can't last forever. You know, like it has to end sometime.
Okay.
Can I follow up on that question?
Sure.
Isn't it true also that the rules of impoundment try to balance some degree of public access with some degree of protection of the right to a fair trial? Do you agree with that?
Yes.
And when you have impoundment of everything, but the right to fair trial can be preserved by just redacting a few lines, do you agree that's the preferable approach?
I believe so, because then the public would have access to.
Right. If you impound everything, the public never even knows that anything that's in the arrest report or that there's even been an arrest, right?
So they would know there was an arrest because of the application, the complaint, and all that.
So ending impoundment in favor of redaction makes more information available to the public while it still protects the accused's right to a fair trial, correct?
Yes.
Okay, just some other questions, and some of these questions came in before you had an opportunity to question them, so they may have been answered, but I'll ask the question nonetheless. Did Mr. Travers ask if Mr. Travers could replace the report? Yes.
Yep.
Okay. And then when you said, I can't do this, what question were you responding to? In other words, I think, what did Mr. Travers ask you when you said, I can't do this?
I felt take that report and take mine out.
Okay. Let me ask a few more questions. Have you ever, before or after October 19th, copied an arrest report, asked the judge for clarification, and assisted in redacting a police report for a DA?
Not that I recall.
Okay. In reviewing police reports, have you seen defendant statements that was salacious?
Yes.
Yes, okay. And when the clerk reviews the application, does the clerk ever make changes to the application? And if so, what changes?
What I would do is I'd look at the charges, read all the charges, and then look what try to find what the basis of those charges are. Like say it was A and B with a dangerous weapon, and there was no a battery. I talked to the one that presented to me and say, I don't see there's enough for the assault and battery with a dangerous weapon, but there's enough for assault with a dangerous weapon. You know, I would have them take any action if they wanted to, or just,
Okay.
I wouldn't change the report myself.
You can't change it. You would ask someone
I
else
would
to
see what
consider.
they wanted to do,
Okay.
you know, whoever presented it to me.
Okay, very good. Are there any other questions, Mr. Bouchard?
Just a follow-up on one of those questions. Now, we're talking 4.5, 5 years ago, right? And you don't remember any of the specific words that you spoke or Mr. Travers spoke, is that correct? Correct. And you don't have a specific memory of him asking questions using the word replace or swap, do you?
I don't remember those words.
Right. But you do remember him asking you, could you take or accept the report? And you said no, correct?
Like I said, it's 4 or 5 years ago. I'm not sure.
Okay, that's fair. All right, thank you, that's all.
Okay, thank you very much. Okay, great.
My witness, I would have been objecting, so you should know if it was silent, it was.
Okay, Ms. Robert.
Good morning, Mr. Keenan.
Mine.
My name is Meredith Fiero and I represent District Attorney Early. We've never met before today, right?
No.
Well, thank you for being here with us today. I'm gonna start just by quickly going through the criminal complaint process with you again. Do you mind if I approach the witness to hand him a document?
Sure.
And the document, just for the record, that I'm handing him is the revised standards on complaint procedure from September 10th, 2008, and we have previously asked you to take administrative notice of this document.
Okay, thank you.
Now, the procedure for applying for criminal complaints is now governed by Trial Court Standing Order 219, which became effective in 2019, correct?
Correct.
But prior to 2019, the procedure was governed by the District Court Standards on Complaint Procedures. I'm gonna have you turn to page 6 of the document.
Is there an extra copy of this document? I don't think we have a copy. Is there supposed to be an administrative notice binder, I think?
I don't, that was going to be given to the presiding officer then. Let me see if I have a copy.
In fairness to you, at some point, we're gonna take a break prior to the witness leaving. And during that break, you'll have an opportunity to take a look at the document. And if any questions arise, you can question the witness on that, okay?
Sorry about that.
I do not believe this is among the documents, so we handed to them at the time.
Thank you.
So are you on page 6?
Yes.
Okay, do you see the first paragraph? Does it say where an arrest without a warrant has been made, the police complainant must file an application for complaint with the clerk's office and attach a police report or other statement of facts which provides the basis for the charges, right?
Yes.
And this is what we previously talked about, that some police departments provide a concise statement of facts and some police departments provide the whole narrative from a police report, correct? And then if you turn to the second paragraph, the statement of facts must include all of the facts necessary to support a finding of probable cause for each element of the offense being sought and identify the accused as the perpetrator. Do you see that?
Yes.
It says include all the facts necessary to support a finding of probable cause for each element, correct?
Correct.
It doesn't say include all the facts that could arguably support a finding of probable cause for each element?
Right.
Okay, thank you. And can you just turn to the commentary section on that page? I'll have you look at the second paragraph. Do you see where it says an application for complaint should be completed on the standard application for complaint DCCR2 form? So there's a standard form that you ask police departments to use when they're applying for a complaint, correct?
Yes.
Okay, I'm gonna have you switch documents for a minute, but still hold on to that. You can put it on the floor if you want. Sorry, we don't have a table for you. Can we show the witness stipulated exhibit number 4?
I think he has it.
Oh, you still have it?
He still
Perfect.
has it.
First, I'll just have you look at the first page. You see at the top left here, it says criminal complaint.
Yes.
It doesn't say application for criminal complaint, does it?
No.
Okay, can you turn to, let me count, 1, 2, 3, the 4th page. This is the narrative portion of, this is what was filed as the statement of facts in support of the application for criminal complaint, correct? Now, this isn't on the standard form that's listed in the rules, is it?
Is there anything missing on the original? Like,
Not to my knowledge.
no, it doesn't say.
It doesn't have the standard form,
It
the
doesn't have
DCCR2 form,
Yeah, it doesn't say that.
not included. And can you just again look at the narrative portion of the package that starts with 3 paragraphs?
Yes.
It's blank at the top of this page, correct? The first half of the page is blank?
Yes.
There's no booking photo of the arrestee on this page,
Correct.
right? And can you tell us why that is?
I don't know.
If the police officer did include a booking photo as part of this narrative, you would remove that booking photo from the application, correct?
I'm not sure.
You're not sure? Are you aware of the court having any standard policy with regard to mugshots of an arrestee?
There wasn't a standard policy, but I think we would frown upon it.
Generally, it was disfavored
Yeah.
because of privacy concerns.
Yes.
Oh, thank you. I think we are done with this for now. If you could just pick up the district court standards again. I'm gonna have you turn to page 11. And now if you could look at the 3rd paragraph, and this is section 203 about authorizing the complaint and determining the proper charges, right?
Yes.
And the 3rd paragraph states that if there's no statement of facts, or if the statement does not contain sufficient evidence to find probable cause, the magistrate may permit the officer seeking the complaint to file the missing statement or to supplement or clarify any statement that was filed. Do you see that?
Yes.
So as far as supplementing, does that refer to an officer filing an additional report?
Some type of statement.
That could happen. And for clarifying the statement, an officer could potentially revise a statement if it was insufficient to support probable cause.
Correct.
And that would be appropriate. Thank you. I'll have you turn to page 21. Now, the 3rd paragraph down, the first sentence states that the magistrate may provide inquirers with neutral guidance and information regarding court procedures, correct?
Correct.
Now, when 88 Travers came to you with the revised arrest report, you perceived him to be seeking your guidance on what he should do with that report, correct?
My memory.
And in return, you provided him with your neutral advice pursuant to this rule. I'll have you turn to page 65. Now, this rule provides that based on common law and constitutional grounds, criminal complaints and most other court records are presumptively open to the public, even though the Commonwealth's general public access statutes do not apply to court records, correct?
Correct.
This is your understanding of the law, that although there are exceptions, generally court records are presumptively open to the public, right? Page 67, please. Now, the second to last paragraph down states that after a complaint is issued, the application, together with any record of the facts presented to the magistrate, including any recordings, becomes part of the criminal case file and is publicly available unless impounded by a judge, correct?
Correct.
So a judge has authority to impound that file or the complaint, correct?
Correct.
But before a criminal complaint is issued, when the application is simply presented, that record is not yet publicly available, is that right?
Before it gets the docket number.
Exactly. Okay, one last page on this document, page 69. The second paragraph states that by statute, the clerk magistrate has the care and custody of the court's records and must keep a record of all proceedings, generalized chapter 218, section 12. Do you see that?
Yes.
So that's the role of the clerk, correct, to have control over the court file?
Right.
That's not the duty of the district attorney, correct?
Right.
And that is a role that the clerk takes very seriously, ensuring that the file is correct and kept properly, correct?
Correct.
And the district attorney, however, it's your understanding that he or she has control over the initiation and prosecution of a case. That's not the clerk's role, correct?
Correct.
Now, the third paragraph, clerk magistrates may, as appropriate, remind police departments and other parties that submit reports to the court, that by law, such reports, once filed, are usually accessible to the public. Since the clerk magistrate has no authority to remove or redact information that by law is publicly accessible in court files, such parties may be encouraged to redact superfluous, sensitive, or highly personal information from such reports before they are filed. Do you see that?
Yes.
Superfluous, sensitive, or highly personal information. You understand that to be information that is not necessary for a finding of probable cause?
Correct.
So this paragraph would give the clerk magistrate authority to encourage someone such as ADA Travers, or well, not such as ADA Travers, would encourage someone such as the court officer who is presenting the application for a criminal complaint to redact or remove any superfluous, sensitive, or highly personal information before filing it, correct?
Correct.
And that would be entirely proper for the clerk magistrate to take that role and to encourage such removal, correct?
Correct.
And it would also be entirely proper for the police officer to go back and revise and remove that information according to the encouragement by the clerk under this rule, correct?
Correct.
But you're not aware that any such encouragement occurred in this place between, I'm sorry, I'll straighten that question, let me take a step back. You were not the clerk who authorized probable cause on the complaint in this case, correct?
Correct.
So you're not aware of whether the clerk who did authorize probable cause encouraged the court officer who filed the application for a criminal complaint to redact superfluous, sensitive, or highly personal information from the report before it was filed, are you?
I am not.
But it would be proper if that such encouragement occurred.
Yes.
Okay, I think we're done with that document, thank you. I'll take that back from you.
Can we make a copy of that?
You do want that right now?
Thanks. Thank you.
Be careful, Stephanie.
I know.
Yeah.
I'm going to hand another, this is a rule to you. Unfortunately, it's not the best quality, so you have to bear with me. And this is another document that we previously asked you take administrative notice of. It's the uniform rules on public access to court records. I think I do. Do you need a copy of that? Because I believe I do have an extra
To
copy.
have that.
You're fine. Okay.
Oh, that's what's.
May I approach the witness?
Sure. So you do have, the
You need to read
petitioner
it
does
back
have this?
Do we have that one either?
You do?
I don't think so.
Okay, I have a copy for you.
It is,
That one I
it was
have.
handed out to everybody, one
Okay.
may not have it.
Here
It's Uniform Rule 14.
I'm gonna start with, all right, so this is Rule 1D. States types of access. Access to court records may be courthouse access or remote access. Courthouse access includes requests to the clerk at the counter and access through a computer kiosk. Remote access includes both an internet-based portal for the public and an internet-based attorney's portal for registered Massachusetts attorneys.
May I ask what page you're on?
Oh, I'm
I
sorry, I'm
can't-
on the first page, it's 609, and it's the, looks like the fourth paragraph. It starts, types of access is the bold.
Okay, all right. I
You see that,
now.
it's D.
Okay, yeah,
No, we already went over that court records are presumptively public, correct?
Yes.
So if a court record is public, a member of the public could access it by either going to the clerk's office and asking you for a copy of the file, correct?
may I just read this? I couldn't see where you
Oh,
were
yeah, for
before.
sure, just let me know when you're done.
Yeah, thank you.
Thank you. So a member of the public who seeks information about a criminal case could find that information by coming to the clerk's office and asking to inspect a criminal case file, correct?
Correct.
And they could also access such information through a computer kiosk that's in the clerk's office, is that right? And another way of accessing this information is through the online portal Mass Courts, is that right? So there's three methods of collecting such information about a criminal case, is that right? Now, we could turn to the next page, it's 610, and I'll have you look at, it's the column on the right that's labeled clerk's responsibilities. Now, it states that pursuant to SJC Rule 312 3A6, the clerk magistrate shall facilitate public access to records that by law or court rule are available to the public and take appropriate steps to safeguard the security and confidential, I'm sorry, it's so hard to read, and confidential responsive court records that are not open to the public. I just completely messed that up. I'll read it one more time. Pursuant to SJC Rule 312 3A6, the clerk magistrate shall facilitate public access to records that by law or court rule are available to the public and take appropriate steps to safeguard the security and confidence of court records that are not open to the public. Is that right? It's hard to read, but
Yes.
to the best of your
That's-
ability. So it's the role of the clerk to safeguard court records that are not open to the public, correct?
Correct.
So that would include impounded records, correct?
Yes.
So the clerk's office takes certain steps to safeguard impounded documents, such as perhaps placing them in a separate file that's labeled impounded, is that right?
Yes. Clearly mark them in an envelope, not impounded, and sometimes we would keep them in the file, keep that.
Okay, so it'd be in
Yeah.
something clearly marked that it was impounded, right, is that right?
Right.
To your knowledge, was that done in this case on the impounded statement of facts?
I don't recall.
You don't recall, okay, that's fair. Now I'm gonna have you turn to page 616. Are you there?
Yes.
Okay, so do you see, I'm gonna have you look at the bottom right, where it says it's the addendum, this lists records that are included from public, that are excluded from public access. It says Massachusetts court system list of authorities designating material as impounded, confidential, or not available for public inspection, is that right?
Yes.
Now, so this is a list of material that by statute, court rule, or standing order is designated as impounded, withheld from public inspection, not available for public inspection, confidential, segregated, or sealed. Is that right?
Yes.
Okay, I'm gonna have you turn to page 619. Do you see on this page, it's on the left, it's the fourth from the bottom, that personal medical information as it is included as some of this excluded material that's excluded from public access?
Where is that?
It's from the bottom on the left column, the fourth up.
Oh, yeah, okay, yes, I see
You
it.
see that personal medical information? Substance use disorder, to your knowledge, is a disease, is that right?
Yes.
I'll have you look to page 620, that's the next page, bottom left column. You stated earlier in your testimony, I believe, I don't recall if it was on direct or cross, that sometimes you will review a statement of facts to ensure that a sexual assault victim's name is not included. Did you testify to that? Yes, and you see that it included here on the list of things that are excluded from public access.
I can't read it.
Oh, that's a bad copy. Oh, you know what? It's the fourth paragraph.
I know it is.
You know it is. Okay. Do you see on the right column? It's the last bullet point. It also it's part of this the sexual assault records that are excluded. It lists trafficking of persons under general laws,
Yeah.
chapter 265, section 50. Is that right?
Yes.
A sexual assault victim includes not only those who are forced to engage in sex acts, but also those who are incapable of consenting due to intoxication. Is that right? Based on your general understanding?
Yes.
And intoxication would include intoxication due to drugs. Is that right?
Yes.
So if someone in a police report stated that they were an addict, that they were sick, that they had performed oral sex to obtain drugs, it's possible, we don't know, but it's possible that that person is a sexual assault victim. Is that fair? If they were so intoxicated from the drugs that they were unable to consent, that's possible.
That's possible.
And as far as the sex trafficking that I showed you earlier, the statute reference, are you aware that in this case, a statement was included in the report that the young woman, I'll just refer to her, had performed oral sex to obtain drugs for her and her boyfriend? Does that ring any bells?
I don't recall the boyfriend part, but I remember the first part.
Okay, and are you aware that, so you don't recall that the boyfriend was actually in the car with her at the time of the crash?
Right.
Okay, well, I'll represent to you that that's the case. If that is the case, is it possible, we don't know, but possible that the sexual acts that were performed, they could have been coerced by her boyfriend to obtain those drugs? It's,
Objection, he said he doesn't know these facts.
Yeah,
I'll move on.
thank you.
I'm done with that document for now. Thank you very much. I'm going to hand up an additional document. This one I do have copies of. I haven't asked you to take administrative notice of it before because it's not a statute or rule. This is a handbook on the trial court rule of uniform rules of impoundment procedure. May I approach the witness?
Sure.
And I'll give you a copy. Thank you.
So do you have a copy of this?
She's gonna provide us
I will
now.
give one. You want one? Thank you. Okay. From time to time, our clerks provided with training for proper court procedures.
Yes.
Do you have any memory of around the time 2005, 2006, receiving training on the impoundment procedures?
Vaguely.
If you will review the document in front of you, does that look familiar to you? Do you recognize that document?
I do.
You've read that before, probably not for a while, but
No,
in the
I looked at
past.
it recently.
Oh, you read it recently? Okay,
Yeah.
perfect. I'm gonna have you turn to page 4.
I just object, presenting off the campus. It looks like from the cover sheet for use with the 2015 amendments. And I think the date. Not really
Yeah, sure.
relevant to.
Oh, well, you can bring that out on cross-examination, on redirect, go ahead.
What page?
4, please.
I have
If
page.
you'll just, oh yeah, there, I think it's double-sided, so.
Oh,
That's why.
I don't have page 4.
Okay, will you just skim the case records and criminal proceedings?
I
for
don't
me?
have page 4.
Oh, you don't have page 4?
It looks like it's just the odd number page with the copy. It's not double-sided.
Yeah, it's, I don't think, you said it was double-sided. The
must have
document you
not
handed
copied.
him is not double-sided.
Okay. Let me just try this.
I have the entire document, it's marked, but
It seems to me you can ask this witness the questions. He
Sure.
hasn't really had to refer to documents, I think, in his 47 years. He's probably learned it, but you know, you do what you want to do.
I'll just ask him, we'll see what we can do. Mr. Keenan, do you recall that as part of your training on impoundment procedures, that you were trained that the public's right of access to court records has to be balanced against the risk for prejudicial pretrial publicity? Is that part of your training? And is it also part of your training that impounded material, as well as material that is subject to a pending motion for impoundment, should not be disclosed to the public?
Say that again, please.
Is it also part of your training that either impounded material or material that's the subject of a pending motion for impoundment should not be disclosed to the public?
Correct.
Is that part of your training? Yes. So if you're aware that a motion for impoundment is coming, but it hasn't yet been filed, or it's pending, you would protect the confidentiality of that information, is that right?
Yes, if I knew that.
If you knew that. Is it also part of your training, I believe we probably went over this earlier, but that when possible, redacted versions of impounded documents should be filed instead of having the entire record impounded?
Yes.
Yes, that's part of your training. I think that's all I have on that, so. And do you recall also attending any trainings in which a PowerPoint was, you know, we don't need to do this, I'll ask you the question, we'll see if you remember. Is it part of your training that there's common situations when impoundment orders are entered, and that some of those common situations are when a defendant's right to a fair trial could be compromised?
What was the first part of the question?
Is it part of your training that there's some common circumstances where a document could be impounded is where that document could compromise a defendant's right to a fair trial?
Yes.
And are you also trained that the court should narrowly tailor the scope of an impoundment, and that the court is authorized to require the filer to submit a redacted copy for public inspection? Does that sound familiar?
I didn't know they were required to.
I'm going to return to the actual events in question, and we'll go off of the rules and trainings. I believe you testified on direct that you recall telling a staff member to bring the statement of facts in this case to Judge Despotopoulos, is that right?
The application, the complaint,
application.
after it was all finished.
After it was finished, not, you don't recall, do you recall bringing the application for a criminal complaint to Judge Despotopoulos after it came in and him remarking that the statement of facts was awful?
No.
You don't recall that? Okay. Do you recall discussing the application for criminal complaint in this case with Clerk Paul Johnson?
Yes,
You remember, again, not the exact words because it was so long ago, but expressing some sentiment along the lines that it was such a shame and that because you see issues like this all the time.
yes,
And by issues like this all the time, were you referring to addiction?
yes,
So that conversation was just simply a casual conversation where you were expressing some empathy for the situation, correct?
correct.
That empathy wouldn't lead you to show favoritism towards the young woman in question, correct?
Correct.
I'm going to turn to your hallway conversation that you testified about on direct. I believe you testified that after you expressed to Judge Despotopoulos what ADA Travers wanted to do, that DA Early said, "Oh, you can't do that." Is that right?
Yes.
That was a question you perceived?
I'm not sure what it was. It was just, oh, you can't do that? It was like,
Yeah.
oh, was it raining out? It was like, just,
It wasn't overly, he wasn't really emphasized.
no, just.
And you don't necessarily remember the exact words, but that was just the general sentiment that
I
you
remember those
recall.
words.
You
I don't
do?
know why, yeah.
But it was a casual question, correct?
Yes.
And after you answered the question by saying, "No, I can't do that." Is that right?
Right.
After you said, "No, you can't do that," DA Early dropped the issue, correct?
Correct.
He didn't press you
No,
on
he
why
didn't.
can't you do that?
No.
He didn't express any anger towards you?
No,
He didn't threaten you?
No.
He didn't say, "I'll give you $50 if you do it"?
no,
The only other thing that DA Early said in that conversation was that he would leave it to Jeff and then he walked away. Is that right?
we leave it in Jeff's hands.
He'd leave it in Jeff's hands. And you took that to mean that whatever happens, he'll leave it with Jeff. Is that right?
Correct.
Prior to ADA Travers visiting your office, DA Early never contacted you about the statement of facts, did he?
You did not.
And other than that hallway conversation that we just spoke about, you had no other conversations with District Attorney Early about this case in the time period in question, did you?
No, I didn't.
And in fact, you never had any one-on-one conversations with District Attorney Early about the case before it was transferred to Middlesex, did you?
No.
Let me just make one correction. It appears I misspoke earlier when I was referring to the trainings and said 2005, it was actually 2015. So I just want to correct the record to reflect that, and I think I'm all set. Thank you very much.
Can I just ask one question? How many cases have you had prior to this one that generated the type of media attention as this case?
Oh, I don't think any that was quite as,
Can you
brutal.
just keep your voice
Oh,
up so they
none,
could?
none that were that brutal, that like Turtle Boy, one of those papers was, I don't want to say vicious, but it was like out there all the time. And I don't remember anything quite like that.
Okay, Mr. Rostoni?
Thank you, Your Honor. Good afternoon, Mr. Keenan. My name is Mike Rusconi. I represent retired Colonel McKeon, who's not present with us today due to a family issue. As far as I recall, we've never met,
No,
correct?
right.
But I overheard you say earlier to Attorney Burke that you recognized him for the barracks at some point in the past,
Yes,
and that would be, because you spent time as a bail commissioner, correct?
correct. Yes,
So when I say bail commissioner, you would be called at any hour of the day or night to show up at a police station or a barracks.
Correct.
To set bail on someone that had been arrested, fair to say?
Can we agree that he wasn't bailing me out,
yeah.
Judge?
You're right.
And I don't think it was that, it was in,
I don't agree with that.
it had nothing to do with bailing anybody out. I think it was a court martial.
So that being said, So you're familiar with the bail statute?
Yes.
That's 276, section 58. And you're familiar with when bail is set, there are considerations by a magistrate or a judge that need to be taken into account?
Yes.
And you'd agree that criminal history is one of those?
Correct.
You'd agree with nature and severity of the crime, potential sentence is one of those? And you would agree that ties to the community, such as a home address or family in the area, is one of those as well?
Correct.
So when you show up to a barracks or a police station, generally, does the officer present you with information relevant to set a bail?
Yes.
I mean, in that, I guess I'm.
Or over the phone, yeah.
Right, so your relayed information, whether it's over the phone or on site.
Correct.
About the arrestee.
Correct.
And the arrestee's criminal history, the arrestee's address or family in the area, things to that effect?
Yes, if not, I ask.
Okay, so you'd agree that if someone just relayed criminal history and the offense itself, that leaves out some information that would be helpful to you in considering bail, correct?
Would you repeat that, please?
If someone just relays criminal history
Oh.
and the offense itself, you'd agree that that leaves out a few factors that you would otherwise consider in setting a bail, correct?
Correct.
So if someone were to just relay those two pieces and you showed up to the station and learned that that person actually lived in the community, had family in the community, and actually had a family member on their way to pick them up, that would change your consideration, or could change your consideration of bail, correct?
I would have asked all that first,
Okay, but let's say,
but if that happened, I can imagine somebody, yeah.
sure. So if, I guess that satisfies my my line of questioning with respect to that. And one, I guess, final thought regarding this event. You said you worked in the courts for 47 years, which is quite remarkable. I think we all agree. And congratulations on your retirement, by the way.
Thank you, appreciate it.
You'd agree you've seen lots of salacious statements in police reports, right? And you'd agree that many times those salacious statements relate to the crime being charged and relate to probable cause, fair to say?
Correct.
And you'd also agree that sometimes they don't relate to probable cause of the crime charged, correct?
I can imagine that would happen.
Can you recall, for an OUI first offense, statements that were as salacious as the one we've been speaking about today? Does anything like that ever ring a bell to you?
I don't recall for an OUI those statements.
Thank you. Nothing further on.
What I would suggest is we take a brief break, okay? So you could gather some of the information and review it. And then we'll come back and we'll do this prior to lunch, obviously, because I'd like to get Mr. Keating out of here if possible prior to lunch, okay?
15, 20 minutes, if does that make sense for a time frame?
So 15 or 20 minute break or 15, 20
For
minutes?
break?
Oh, you want about a 15? Okay, let's do it on the short. So we'll come back at 12:30.
Very good, thank you.
Okay, thank you. Okay. Okay. Okay, okay, we're on the record now, Mr. McDonald.
Thank you, President Kentowitz. The petitioner does not have any questions for Mr. Keenan on redirect.
Okay, thank you very much. And
Judge, I would just like to offer the 2015 handbook on the uniform rules of impoundment procedure, and as an exhibit, I believe it would be number 18, is that right? Or 17B or something? Oh, all right.
Sure.
Number 20.
I'll defer to the stenographer.
I was under the impression 20 would be the next exhibit.
Okay, thank you.
okay, hey, Mr. Burke, you have any, Ms. Garrett, do you want to give her the document?
Yes.
Okay, so just make it.
Were you able to make copies? No. We will provide copies.
Okay, thank you.
Yeah, this wasn't the double-sided one.
Ms. Farrar, I'll just ask you to do it in, when you have the document.
Thank you.
Okay, thank you. But that will be exhibit 20, okay? Ms. Burke, do you have anything on recross?
I do.
Okay, thank you.
There was no redirect, so I guess I'd object to any recross.
I know, but he's allowed to ask questions based upon the subsequent questioning of the other parties.
Based on the subsequent question of the respondents, counsels?
No, based upon the question asked by one of the commissioners.
Yeah, even better. So, okay,
We are seeking the truth here, right?
okay, Mr. Burke.
You were asked by one of the commissioners a question regarding whether or not the situation had appeared in the same status and situation before. Do you remember that?
Would you repeat that, please? Sure.
You were asked a question, Judge Kantrowitz asked a question that a commissioner had asked regarding whether or not you had seen this occurrence before in terms of a redaction. Remember that question? Let me ask it a different way. Do you consider yourself to be a fair person?
Yes.
Do you distinguish between somebody who is poor or somebody who's rich?
No.
How do you deal with them in the courts?
No.
Do you acquire or provide any special consideration because a person is an attorney, for instance?
No.
And do you treat people as fairly as you can under the circumstances that are presented to you?
I always try my very best.
If the daughter of a truck driver had been arrested under the same exact circumstances, and their defense attorney had filed a motion to impound under the exact same circumstances, other than the fact that it was a truck driver's daughter, would you have treated that person any differently than you did here today?
No.
Than you did in this case?
No.
Okay. I have a 30-year-old daughter. If my daughter was arrested under the same circumstances, would you have given me any different or special treatment because of my rank or perceived rank as a lawyer?
No.
Did you give Mr. Judge Biambo's daughter any particular difference in terms of your treatment of her because she was the daughter of a judge?
No.
Thank you. Ms. Bourgeois, anything?
Nothing, thank you.
Nothing? Okay, Mr. Scone, nothing? Thank you. Sir, have a good lunch and thank you.
Thank you.
Good luck to you in your retirement.
Oh, thank you. Your
Okay,
Honor.
thank you for your service.
Bye, everybody. Thank you.
Thank you. It's 20 to 1 now, so it would seem to be an opportune time to take the lunch break, but I'll defer to the parties, so. Do you have any preference? Parties have any preference?
I would prefer taking a break, Judge, but obviously it's.
I didn't hear what you said.
I would prefer doing lunch break, but it's up to you, Mr. Bourgeois.
You know, there's something to be said for getting started and taking a break instead of a long-term afternoon, but, you know, it is 20 hours, so I'll your discretion.
Okay, so,
We'd really like to take a lunch break.
okay, so, okay, why don't we take the break and we can go, ordinarily I would do an hour, but if you want to get going a little earlier, we can do it in 50 minutes at 1:30. Would you prefer 1:30 or?
No, I mean, I'm fine. I would estimate my direct examination is probably gonna be an hour, maybe a little bit more. That's
Okay.
my best estimate.
Okay, and, well, if we have to stay to past 5, I suppose we can use.
I laugh only because this one would be my witness, and who knows, is all I could say.
Okay, I'm confident you'll be brief and to the point.
Yes.
Okay, well, why don't we play it by ear? I'll see you in an hour then, 20 to 2, and then we'll get going. If we have to run late today, it's fine with me, but I'll hear from the other parties too.
And I'm here tomorrow morning, so.
Okay,
if it
okay.
goes over.
Okay, so we'll see everybody in an hour. Thank you very much.
Thank you. Thank you.
The stenographer is marking 2
Okay.
things for identification.
So tell the truth, all the truth, so help you God.
I do.
Okay, thank you, sir. Let's wait for the court reporter.
Give it back to the attorney, or do you want them, Mr.
May I take them?
Sure.
I'll use them shortly.
Sure,
Thank you so much.
okay. So the witness has been sworn, so, and Mr. Bourgeois, the floor is yours, sir.
Thank you, sir. Would you please tell us your full name and where you live?
Yes, sir. My name's Jeffrey Travers. I live in the town of Sutton, Massachusetts.
And what's your occupation?
I'm an attorney, and specifically, I'm the Senior First Assistant District Attorney for the Worcester County District Attorney's Office.
Are you married?
I am.
You have children?
I do.
How many children?
I've got 2 children, 20 and 21.
Okay, and do you live with any other members of your extended family?
I do. We have a multi-generational household in my house. We have my mother-in-law is 84 and she's blind. And her sister is 91 and she's blind.
And would you summarize for us your educational background, at least after high school?
Sure. I went to St. John's High in Shrewsbury. I went to UMass College in North Dartmouth. It used to be called Southeastern University of Massachusetts. After I graduated from college, I worked for a few years. Then I went and got a master's degree at Anna Maria College in Paxton. And it was a master's in counseling psychology. My undergraduate degree had been in psychology. Working days at the DA's office, I finished that, and working days at the DA's office, I applied for law school, graduated from Southeastern University of Massachusetts Law School, which is now UMass Dartmouth.
Tell us a little bit about your family background. What's your father do for a living?
Sure, I grew up in a family around the law. My mother's father was a policeman. My father worked in the district attorney's office in Worcester County when he was a young lawyer. He moved to the attorney general's office where he was the chief of their criminal bureau. Over the years, he moved to the U.S. attorney's office. He was the U.S. attorney for Massachusetts. He was appointed to the Superior Court bench, and he did the rest of his career as a Superior Court judge until he retired at age 70. I have an older brother who's an attorney, who had been an assistant district attorney in Worcester, also had been a defense attorney. I have a nephew who's an attorney.
Would you tell us, please, a little bit about your rise through the district attorney's office and particularly your work before you were a lawyer there?
Sure, I guess I kind of moved in and I never left. I went into the DA's office while I was going for my master's at Anna Maria College. And I was interested in counseling at the time, and they had an opening for a victim witness advocate. So I went to work at the DA's office, working with victims in criminal cases, helping them to connect with the assistant DAs, understand the court system, and connect them with resources for issues that they were having as a result of the criminal case that they were needing. Maybe it was counseling or the like. And I did that for about 4 or 5 years. They, at one point, were looking for an interviewer to do child appropriate interviews in the DA's office. That was the beginning of a program that trained the DA to kind of be the central focus for interviewing children so that they weren't being interviewed multiple times about abuse or neglect. When we started, the DSS would do an interview, maybe the teacher did, the pediatrician, the police officer. We brought them all under one roof. I was trained as one of the first 2 interviewers in Worcester County to do child forensic interviews. As I went through my law school career, in the last year, you get to do 303 practice. That's where.
What's a 303 practice?
So a 303 is a student lawyer who works in a law practice. In my case, it was in the Worcester Juvenile Court District Attorney's Office. And you get the benefit of working under a supervisor who's experienced in the law, and you get to actually try some cases. So I did that in my last year of law school, which would have been 1997 into 1998. I took the bar and I passed the bar, unfortunately, the first time, and I was sworn in December 1998, and I was immediately sworn in as an assistant district attorney, where I remain to the current day.
Now, when you started working in the DA's office before law school, who was the district attorney?
So John Conti was the district attorney for Worcester County when I entered the office in 1992, up through his retirement in 2007, at which time District Attorney Early came in.
So when you started working for Mr. Early, you'd actually been in the office how many years?
About 15 years.
And Could you tell us a little bit about your rise through different positions as an assistant district attorney?
Sure. As I was testifying earlier, in law school, I got to work in the juvenile court, and when I passed the bar, I stayed there for a period of time. I was prosecuting initially as a student lawyer, mostly delinquencies, not particularly important delinquencies. After I passed, I got to do some more significant things. In fact, cases you don't typically do in a district court, because the juvenile court has jurisdiction over every offense, including felonies, with the exception of murder. So I did some life felonies while I was prosecuting in the juvenile court in Worcester. There were youthful offender cases, so robberies with shootings, robberies where people were locked up, confined, sexual assault cases. It was a very interesting opportunity. After I was there for a period of time, I was promoted to the Worcester District Court. During that time, DA Conti had sort of a division of staff where if you were in the district court in Worcester, you were either doing matters that went before a single judge in a bench session, or you were assigned to a jury session. Initially, I and a lot of young lawyers were assigned to that bench session, where you'd receive a file after it had been arraigned, and you do all the pretrial procedures, the motion practice, up through and including a bench trial. And that at that point, a person could elect, if there was an over at one point, we could have a bench trial and then still have a jury trial. But early in my career, really, it became you elected. Either you had a bench trial, and that was handled by the people like me in a bench session, or it went to a jury of 6. So I was in the bench session in the Worcester District Court for a period of years.
What'd you do next?
So I got promoted to the Worcester jury session. There you are really receiving files where all the work's been done from arraignment through jury election. And really, you're just picking up the file and you're going. You're gonna try it, or it's gonna be resolved on the day of trial. It's, as you've all heard, a very busy court. They do about 9,000 cases a year. So it was me and a group of trial attorneys that were just trying jury trials in the Worcester jury of 6.
And what was your next position as an assistant district attorney?
Sure. So after I had been in the jury session for a period of time, someone identified me for promotion opportunity to the Superior Court, specifically to the child abuse shooting. I've been a victim advocate, I've been a child interviewer, so I think they saw that background combined with my trial experience may be a good choice for the child abuse and sexual assault unit. So I was assigned to that unit around the year 2000. And I remained there for a period of time prosecuting child abuse cases. It was a particularly interesting assignment because unlike when you're in the juvenile court or the district court in Worcester, you don't just get a file that's been processed by the clerk's office and take it over from there. As a sexual assault unit prosecutor, you're actually very involved with the investigation of those cases. Like I described, you're involved with the interview of the victim, who's the most critical witness. You're involved with the police around decisions in their investigation, search warrants that are done, what those warrants look like, evidence that's secured, collaborating with medical professionals around the child's injuries, getting the case into a district court where it's charged, and I would be doing the arraignment, making decisions around whether that case is going to the Superior Court. Then I'd be presenting the case to a grand jury with that child. And then ultimately, if the case is indicted, I would sign the indictments after I've selected them and would bring the case in for arraignment anew in the Superior Court. And I'd be doing the trial practice right through trial on those cases as well.
What happened next in your career?
So I was in the child abuse sexual assault unit for a period of years. It was wearing a bit on me. I saw there was a job opening with the Sex Offender Registry Board. I took that job for a brief period of time, around 2005, 2006, doing administrative work as legal counsel for SORP.
How long were you with that board?
I was there for about 6 months, and something happened at the Worcester DA's office that opened the door for me.
Okay. And what happened next in your career?
So the chief of the child abuse and sexual assault unit retired. And I spoke with DA Conti at the time, and he offered me that position to come in and be the chief of the child abuse and sexual assault unit. I accepted that position, and I was then coming in to manage that team of about 6 attorneys that were handling child abuse cases. We had a team of 3 forensic interviewers, victim advocates, administrative help in handling all the cases that were coming in, as well as the on-call associated with that, because it's 24 hours a day. Children are being abused, neglected, and reports are coming into the office through DSS or law enforcement.
And you supervise that entire unit?
Yes.
What happened next?
So DA Early came in 2007, and sometime shortly after he came into the office, there was a death in the office. There was a very well-liked Superior Court prosecutor who was handling some, I'd say, legally complex matters. He left the caseload when he died suddenly, and I was asked if I'd step in and take on those cases. There were homicide cases, there were arsons, there was a particularly complex arson involving a Worcester firefighter who burned a property. There were home invasions, all kinds of life felonies. So it was an opportunity to do something new in Superior Court, away from child abuse and sexual assault. And it was a great opportunity for me. So I started doing that.
And in that position, did you try some of those major felonies?
Yes, I did.
What was the next thing that you encountered in your career?
So I was in the major felony unit trying cases until, I want to say around 2013, when the DA Early brought in a new position he created for a senior first assistant district attorney. This was a supervising attorney who had a lot of litigation experience, who came in to kind of sit in a position above what had originally been the first assistant's role. That person was Dan Bennett. Dan was someone that I knew a little bit when I was a child abuse, sexual assault prosecutor. I'd had a case with him. He had defended a teacher from Bellingham who was charged, convicted with sexually abusing a student. I'd interacted with him a little bit. He knew I'd gone to SORB. He had a family member with SORB, so we knew each other a little bit.
SORB is Sexual Offender Registry Board, right?
Yes. So Dan came into the office around that time, and he reached out to me to talk a little bit about the office, kind of, what are the things good and bad. When he came into the office, he had spoken with DA Early, and the DA had offered me a position to supervise the motor vehicle homicide unit. So that was my next assignment. And that was around 2012, 2013.
And what happened next?
So I supervised the motor vehicle homicide unit. A lot like child abuse, it's a unit where crimes are occurring in real time, and you're a part of a 24-hour response. In that unit, unlike child abuse, you are more likely to go out to a crime scene where there's a death on scene, and work with law enforcement to review charges, seizure decisions, warrants, all those kinds of things, and make reports up the chain of command to and including the district attorney. So that was something I did, and I prosecuted those cases.
And in that position, would you work directly with police officers on issues like how to prepare arrest reports and what goes in an arrest report?
Yes, very much like child abuse, you're out at scenes, working hand in hand with law enforcement. And there was a multi-agency often response involving state police, local police, and bringing those pieces together to a charge, the correct charge with the correct facts.
What was your next position in the DA's office?
So the chief trial counsel for the DA's office retired. And that person was Tom Landry. The chief trial counsel is a position within the DA's office that supervises all of the Worcester Superior Court, all the prosecutors. We work closely with the judges in the clerk's office, handling things like governor's warrants, renditions, maintaining the docket so that murder trials are scheduled in a way that'll work for the court's calendar. I came in and I was offered that position by DA Early, and I accepted it. So I worked immediately under Dan Bennett, supervising the Worcester Superior Court. And again, during that time, had my own caseload of major felonies, including motor vehicle homicides I carried from the prior assignment.
And what happened next in your career?
So in 2015, Dan Bennett left the office. The district attorney spoke with me, asked me if I would accept the position of senior first assistant district attorney, and I did, and have remained from 2015, February, I believe, for the current time.
Hey, would you tell the commission, if you could summarize the different responsibilities you have as the first assistant district attorney?
Sure. So there are a lot of very, very different things that I do all the time. I manage the day-to-day operations of the district attorney's office. And those include all the things of a large law firm. We have 80 assistant district attorneys, victim advocates, support staff, fiscal staff. So I handle all the things associated with that kind of a thing. Hiring issues, interviewing issues, background checks, discipline issues, termination issues. Issues around budgets and budgetary controls I'm involved in. The civil business at the district attorney's office I'm involved in, which would include sexually dangerous person petitions and forfeiture civil actions. So all of those things would come through me. Often in the sexually dangerous person petitions, I'd be the person that would authorize filing a civil petition and issues around retaining experts and funding those experts. I'm also involved in collateral kind of work with interagencies that have to occur. Contacts with the U.S. Attorney's Office, the Attorney General's Office, the District Attorney's Office, the Massachusetts State Police Crime Lab. If there's to be exhaustive testing and investigation, I'm the only person that can sign off on that. If there is to be expedited testing, I'm the only person that can sign off on it. If there's to be testing that can't be completed in the Mass State Lab, but needs to go out to an outside private laboratory, I'd be the person that would authorize that. Contact with the medical examiner's office would go through me, particularly around unattended deaths and deaths that are suspicious or known to be homicides. Also associated with death investigations, the New England Organ Bank takes an interest in harvesting organs associated with deaths. That would go through me and the medical examiner's office to coordinate that the correct evidence is maintained. The medical examiner's office constantly reaches out to me about what depth of investigation they need to perform based upon the nature of the investigation, criminal, non-criminal, that kind of thing. In addition to all that, I supervise all of the dispositions in the Worcester Superior Court, whether it's a plea or a post-conviction sentence recommendation. The prosecutor would come to me, we would meet, they would have a memorandum of the facts of the case, the person's board of probation record within Massachusetts, the III or interstate record of criminal behavior. They would provide me with not just the facts, but the input from them on the issues of proof, their input from the family or victims associated with a crime, and in addition to that, input from law enforcement involved in an investigation. I also supervise dispositions and problems with cases in the district courts around Worcester County, particularly motor vehicle homicides, a case that involves a death or a substantial likelihood of death. Those kinds of recommendations would go to me, and I would alert the district attorney and probably the most sensitive matters, motor vehicle homicides and anything else that I think should come to his attention from practice of talking with him about things.
As first assistant district attorney, do you have a particular role in cases that involve a potential conflict or might involve somebody who had a relationship with your office or with the court, that kind of thing?
So yes, I'd handle that, and we're also a 24-hour a day assisting law enforcement agency. So I have all of the units, many of them I've been involved in, that are reporting to me in real time, by email, by text message, by phone call, about events that are happening during work hours, but often 24 hours a day. Things like a suspicious unattended death or a murder. That call would come from the law enforcement agency handling it to me directly on my cell phone. If there's a child abuse investigation that appears to be sensitive, with a substantial likelihood of death, or actually death occurs, the person that's on call is going to call me to fill me in on that, and in turn I would inform the district attorney. Arson investigations are forwarded to me 24/7. If there's the death of a firefighter or a substantial injury to a firefighter or a citizen, that's gonna come to me in a phone call or some other direct communication. There are similar things with the gang unit, obviously the motor vehicle homicide unit. If there's an investigation with a history of domestic violence, for example, then there can be concern that a crash can be intentional. If the evidence at the scene of a crash indicates, a direct line of travel with no breaking into a hard object, that would suggest intentional conduct, whether it's suicide or otherwise. So there are things that I'm handling kind of 24/7, and specials is among the things that come up.
Do you often have to leave your home in the middle of the night to go to scenes?
Very, very often. I leave my house to go out to scenes, and I stay at the scene until that scene is resolved, or I can get some relief from someone that's on call, whatever day or day of the weekend it is.
Mr. Travers, in your career, by the way, when you're doing all of this, do you have your own caseload also?
I do. I really handle homicides. I might be a motor vehicle death, it might be an arson with a death, or just a straight up murder. But those are the cases I'm handling.
And in your career, have you prosecuted important, popular, or influential people?
Yes, I've been selected under DA Conti and DA Early to prosecute people who were public figures. I've prosecuted 3 or 4 police officers. Prosecuted a court officer on multiple counts in the Superior Court who went to prison. Prosecuted at least 3 Catholic priests, 2 of which went to prison. I have prosecuted a Protestant minister in the Worcester Superior Court. I have prosecuted the firefighter I mentioned who burned the property. I prosecuted multiple teachers. More than one of them's gone to state prison, men and women.
Have you, in your career, had to make decisions to dismiss cases where the decision might have been unpopular?
Yes, absolutely. I am in a position where my duty as an attorney, and it's been referenced, a minister of justice requires me to follow the law. And I've had occasions where I have to tell people that a case is not legally prosecutable to a jury verdict. And for that reason, I've dismissed cases. During this pandemic, I had a case come up during the Black Lives Matter demonstration where the Worcester police arrested a large number of people. I had concerns about the law that was applied to them that had to do with unlawful assembly. In that case, I was handling the cases exclusively because of a perceived conflict within the office. And I assembled some people from our appeals unit, our district court staff, and I examined. And in the case of about a dozen cases, elected to terminate or dismiss those prosecutions based on a fair review of the evidence under my obligations as a prosecutor.
Mr. Travers, in your career, have you ever been disciplined by any agency that oversees you as a lawyer, as an advocate, or any other profession of law?
Absolutely not.
In your career, have you ever been sanctioned or disciplined by any judge or any tribunal that you've ever appeared in front of?
Absolutely not.
Have you ever been accused of professional misconduct by the Board of Bar Overseers that regulates lawyers?
Never.
In your career, has any case that you were a prosecutor on ever been reversed by an appeals court or the Supreme Court based upon any error or thing that you said or did in that court?
No.
Mr. Travers, have you ever received any awards or professional recognition or accolades as an assistant district attorney?
Yes, in 2009 or 10, I received an accommodation from the Federal Alcohol Bureau of Tobacco, Firearms, and Explosives for my prosecution work of a Worcester firefighter who had committed arson of a home. He was flipping in the city of Worcester. Most recently in 2022, I received another recognition from the Bureau of Alcohol, Tobacco, and Firearms for prosecution of an arsonist that resulted in the manslaughter death of firefighter Christopher Roy. I prosecuted a person for OUI manslaughter was the conviction in the operation of a motor vehicle that resulted in the death of Trooper Thomas Clardy. In that case, Colonel Gilbert recognized both the office and myself directly for my prosecution work in that case. In 2019, I was elected by all of the district attorneys in the Massachusetts District Attorneys Association to Prosecutor of the Year and received that award.
Mr. Travers, I want to ask you just about your relationship or friendship or prior relationships with some people. First, let's start with Judge Bebo.
Sure.
What was your relationship with him before these events?
So before these events, when I was working in the DA's office, Judge Bebo was an assistant district attorney who worked primarily for John Conte. And then I think he stayed on for a year or two, perhaps, after DA really left. I really wasn't around him when DA really came in, so I don't really know how long he stuck around before he was appointed to the judgeship. In the DA's office, he was another prosecutor who was older than I, who worked in different areas of the office. Like I said, we got about 80 lawyers. I knew him to work in other areas where he was not my supervisor, I wasn't his supervisor. I think at a time he was supervising the district court in Worcester when I wasn't there, and he was supervising maybe drug cases, that kind of thing. So I knew him to say hello.
Did you ever socialize with him?
No.
Visit his house, anything like that? All right. What was your prior knowledge or relations with Ally Bebo, his daughter?
Sure. So I believe she was a victim advocate when DA Early was in office. I couldn't tell you for how long. And it's my understanding that her employment was terminated by Dan Bennett, I believe. I don't know what kind of cases she was an advocate for. We have different units. I know she was assigned at the courthouse when I was assigned to the building across the street. We didn't have any cases together. I knew her to say hello, like all the advocates. There was one occasion when I we have a kind of a counter with a window you've heard about, and someone was at the counter that spoke Spanish only. She was bilingual, so she helped to communicate what the person's question was to me. And I think that's the only time I can think of when I've ever had really involvement with her, working with anyone.
Was there any friendship or social?
No.
Tell me about your social arrangements or relationships, if any, with your boss, Joseph Early.
My boss, we don't socialize outside of work. We spend some Saturday nights at crime scenes, I guess, but I wouldn't say it's social.
All right. And tell us about your relationship anything with the defendant, Richard McKeon.
Colonel McKeon, I knew as a trooper, I guess initially when I came into the DA's office, and he was working in the State Police Detective Unit. I think by the time I was actually a prosecutor, he had attained sub-rank within the State Police Detective Unit, certainly handling matters much more serious than anything I was involved in at all. He would have been the kind of person that was handling murders, the Molly Fish type investigations, that kind of thing when I was handling things in the juvenile court or the Worcester District Court. I understand, had been promoted to run the State Police Detective Unit, but not during a time when I was managing the Superior Court. I didn't have cases with him particularly that I can ever recall.
Any friendship or social relationship?
No.
And last but not least, can you tell us any prior history or relationship or friendship you might have had with the respondent Susan Anderson?
So I met Susan Anderson for the first time when I was walking through the door at the beginning of these hearings, and she was nice enough to say hello. That's the only time I've.
You never worked with her?
No.
I asked you this before, and I wanted you to expand on your answer. As first assistant, do you have any special role or responsibility when there's a case involving a potential conflict of interest or someone who worked at or used to work at your office has been charged with a criminal offense?
Sure. Anything that's identified as a potential conflict for our office would be brought to my attention, and it could be from anybody. I've had advocates, administrators, lawyers, supervisors, anybody could bring it to my attention, and I would try to get some information. What's the nature of the conflict? What's the underlying case? If I can get a police report, some facts about it, when's it coming up, that kind of thing. It happens to some degree of frequency. I'd make a review of, is it actually a conflict? And then what's the office's response going to be to what kind of a conflict it is?
And what are some of the potential responses?
Sure. So I think there are conflicts that are apparent conflicts. In other words, somebody from the outside might see this looks like a conflict. And then there were cases of true conflicts. For example, a defendant in one case is a victim in another. So we might create some separation within the office and have the cases handled by two different prosecutors. We've got 80 prosecutors. There is some degree of turnover in the district attorney's office, so it's not unusual at all that I could pull in a prosecutor from another court to go in and handle the matter. They would have no familiarity with the parties. They'd leave and come back until the case is completed. Alternatively, we have a number of attorneys that work within Worcester County who act as special prosecutors for us under a fee agreement. There have been many occasions when I've asked an attorney that works within Worcester County if they're indifferent and if they're willing to take a case as the special prosecutor, in which case they would I get all the reports together, funnel the information to them through an administrator, and they would take over the case on a date that's convenient for their first appearance.
And is that a phrase that you use, special prosecutor?
Yeah, it's a common expression, a special prosecutor, just meaning it's not the normal prosecutors from the office. And then there's a third option where sometimes cases are referred to another county to ask them if they would come in and prosecute a case. So there've been occasions, and it works both ways, or one first assistant would call another. I would reach out to a county and say, would you be available? Would you have someone that could come in county? We'll swear them in as a prosecutor, and they'd handle that case. Typically, we try to pick counties that are kind of close-ish to where the court is. So we call the DA's office from perhaps a bordering community. Sometimes it just doesn't work that well, because someone might owe you kind of a favor. You've done a case for their county, so they kind of owe you one to come in and handle it.
Were you here during Judge Dolly's testimony?
Yes. Okay.
I just want to clarify the decisions that he makes versus the decisions that your office makes. Does your office have any role in the decision of which court or which judge hears the case?
No. If we get a special prosecutor, the case stays on its track, whatever track that is the court has. Typically, it stays in the court it was in, and it keeps tracking along with the special prosecutor coming in. His mention of a transfer order is something that's totally separate. Typically, special prosecutors come into Worcester County and handle the cases. In the much rarer instances where a court transfers the case, then that places the case into the jurisdiction of another court. And in that instance, we typically call that county to say, hey, the case is going to be in your court. Could you please pick this up so we don't have to travel?
Okay, now I'm going to ask you the reverse question. Does Judge Dolly decide who's going to be the prosecutor on a conflict type case that's going someplace else?
No, not at all. Under the separation of powers, the prosecutor and the trial court have very different roles.
Okay. Sometimes does Judge Dolly's decision about where the case go have an impact on who you use as a prosecutor or whether you use a special prosecutor?
It hasn't come up all that often, the cases are transferred to another court, because typically that reflects a conflict with the court, and it just doesn't happen as often. I have seen it, it's probably been after this case that a case got transferred, so then I call up the court where the case went to. At the time this happened, it was unusual because I was actually trying to connect with another county to see if they could come in and handle the case, but it was transferred somewhere else.
Well, you anticipate my next question. Let's bring this now into this particular case.
Sure.
What was your role as first assistant in connection with the Ali Bebo arrest and prosecution? What were your responsibilities?
So as the first assistant, when the conflict is identified as a potential conflict, it's directed to me. All the information about the case is directed to me. I would make an evaluation, is there a conflict here? I might consult with the district attorney. In 2017, that was more my practice, that I would consult with the district attorney about the appointment of a special prosecutor. And once that decision's been made, I would look to see what options were available. In-county attorney, out-of-county attorney. And then I'd start to get the information and I'd reach out to that county, if it's another county, see if they'd accept it and get them the case information and try to get a date that works for them because they're traveling.
Had you previously had experience in dealing with special prosecutors involving Ally Bebo?
Yes, there'd been a prior case within months previous to this.
Okay, now these events were in October of 2017, is that right?
That's right.
Do you remember when the first arrest was?
It might have been May or March, I want to say.
And did you have a role in that?
Yes, and so that case was referred to my attention, and it ultimately went to a special or, a prosecutor outside of our office who was working in the defense bar. And particularly it was an attorney that was working in northern Worcester County, so we really have no connection to the people who were the potential conflict or
Okay.
apparent conflict.
Now, before I get into the specifics of the Bebo arrest and some of the things that we've already talked about, I want to ask you, in your job in working with police on major felonies, do you sometimes provide guidance about drafting arrest reports and editing arrest reports?
So absolutely, I work with police very hand in hand and work on things like police reports and probable cause statements or probable cause reports, whatever language you want to use, the content in them, what's going to be public, what should be included, what shouldn't be included. That's a pretty common thing.
And have you ever advised or told a police officer to remove something that was salacious or provocative or quotation said by a defendant? Have you ever done that?
Yes.
And can you give us examples of some of the cases where you've done that without getting into the specifics of identifying something if you can?
So in a murder case, I've done that a number of times, particularly with quoted or attributed statements. A person's statement that's an admission or a confession shouldn't be in a public statement of facts. I've done that with things that are prejudicial because of their potential to be read as bringing on public kind of condemnation. I've done that with things that might be behavior that would suggest consciousness of guilt. I had a homicide where a person put a knife through their neck.
What?
I had a homicide where someone put a knife through their throat after murdering someone in the same household. That knife in the neck didn't need to be in the probable cause statement about the death of the domestic partner. I've had cases where way too much information was put into a probable cause or statement of facts to support a criminal complaint and sexual abuse cases that I handled. I was involved with a teacher case with a female who was both a teacher and she was a foster mother. And she was alleged to have committed sex acts with her foster child who was a former student. That person, because of their status as a teacher, foster parent, garnered a great deal of media attention at the time. And the police at the time put in essentially an entire police report describing, quoting things that should not have been under the rules of professional conduct. I spoke with the investigating trooper. In fact, I wrote a memo to the district attorney back in 2007 describing what had happened, the problem, and that I'd addressed it, and that the detective was going to speak with his chief about not doing that again.
And have you ever taken steps, be it impoundment or redaction or other types of actions with the court to remove information from public view that you felt was, I guess, beyond the pale in terms of potential publicity and prejudice.
Yes, so there have been a variety of cases where I've had to do that. Cases where too much information was put in, cases that might jeopardize the safety or security of a witness or victim. A lot of different instances where information has to be filed, but you can control what should be filed for a risk of violating our rules of professional conduct.
Have you ever had a case where somebody was initially charged or suspected with a sensational trial and it turned out they were innocent?
Absolutely. I had 2 cases I can think of off the top of my head like that. I had a person that was a youth sports coach in the Uxbridge area who had been the subject of a tip to the Massachusetts State Police. There's a system that tracks child pornography and makes referrals to local law enforcement around the country. That happened in that particular case, and it tracked back to the household of a youth sports coach. And the person, the evidence would show that there was a downloading of pornography using a credit card that was associated with the coach. It was the subject of a search warrant where police went in and secured computer equipment within the household. And a search warrant's initially a private document when it's secured from the clerk, but when it's filed within the 10-day filing rule with the return of service, it becomes a public document. In that case, it was a concern that there'd been credit card fraud, which in fact turned out to be true, that person actually hadn't paid for the child pornography. It was their card that had been misused. So it was extremely important to me that person not be labeled a child molester or a child pornographer based upon the return of that search warrant. So I moved to impound it, the court allowed it. And similar to that, I had a case in the Westboro District Court where a person with extraordinarily deviant sexual interest that ran towards children was engaged in all manner of abuse, including all kinds of objects and the like, piercings and that kind of thing. But there was a concern as to the testimonial faculties of the child that was the source of the information. So in that case, I spoke with the prosecutor and an effort was undertaken to impound what was an extensive filing of information in order to prevent, prejudicial pretrial publicity and control the information and let it be heard at trial, not in filing a complaint.
You've talked about probable cause statements and arrest reports. Maybe it's obvious, but just briefly, would you explain to us the difference between the 2 documents?
Sure. So a probable cause statement is totally different from a police report. And there are different terms that are used, and some of it has to do with forms and some of it has to do with how old you are. The paperwork, that template that's attached to an application for complaint, you'll see at the top of the template that traditionally goes with that is statement of facts. It's printed on the top of the form. So a lot of people say statement of facts because that's the document that traditionally was completed by police, along with a statement of facts application, which is like 3 pages on top of that record. It was a document that was done in multi-layered carbon copy back in the day. That rule in those documents, the way that they're filed with the court, has changed over time. So you still hear statement of facts, which is sort of an older term. You still hear gist, which of course is a summary, a condensed summary of information. That's also used to describe a probable cause statement. Alternatively, and more modernly, you'll hear probable cause report, I would say, or a probable cause statement. So those all mean the same thing. They're a document that's filed with the court to support that application for complaint document, and it is used to provide information to support the elements of the crime that are being sought by the law enforcement personnel. It's a public document.
All right, so the police officer's arrest report or incident report that they make of what happened in the field in the arrest, is that always the same as the probable cause report?
No. The probable cause report is there to support the probable cause to issue a complaint. A police report may be a much more expansive document. It should be a much more expansive document that's not a public record.
In this case, is there a significant difference in terms of the substance? We're talking about Ali Bebo's second arrest, between the arrest report and the probable cause statement.
No, essentially, they were the same thing.
And with your permission, sir, I'd like to show the witness the documents we've marked as A and B for identification.
You have copies of those?
They're the documents that I sent you over the weekend. The answer is no. I sent them to you on Saturday by email. And Mr. Zaw has them.
Can you identify them for the record?
I'm going to have them do that. Right now, they're A for identification and B for identification.
Thank you.
Okay. And Mr. Travers, would you just tell us generally what the document marked A for identification is?
Yes, this is material I saw with the petitioner's production of discovery. It is, I believe, the court file from the Westboro District Court in Ali Bebo's first criminal matter.
That was, and you had speculated that was a few months earlier than October, just from the document. Can you tell us the time frame of that?
Yes. The date of the arrest is May the 12th, 2017. The complaint issued May the 15th, 2017.
Okay. And the document that's marked Exhibit B for identification, can you tell us what that is, please?
Yes, Exhibit B is an 8-page Shrewsbury Police, looks to be an arrest report, an incident report, they call it. It's a full police report on that now.
Okay. And you're familiar with both of those documents?
Yes.
And you're familiar with them because you had a role in the first arrest, is that correct?
That's right.
And to the best of your knowledge and information, is Exhibit A for identification a true and accurate copy of the records of the Westboro District Court, prepared and maintained in the ordinary course of the business?
Yes.
With respect to Exhibit B for identification, that's the Shrewsbury Police Department, is that correct?
That's correct.
To the best of your knowledge and experience as a law enforcement person, is that document prepared and maintained in the ordinary course of the Shrewsbury Police Department's business?
Yes.
And what I ask you to do is to compare, if you will, the probable cause statement in the first arrest to the arrest report. Just look, can you get the two of them ahead of in front of you?
Yes, I have them both here.
With respect to the first arrest done by the Shrewsbury Police Department, can you tell me approximately how much of the narrative of the arrest report found its way into the probable cause statement?
Somewhere around 20-25%.
A quarter or less?
Yes.
And that's compared to what percentage in the second arrest?
100%.
In the Shrewsbury Police Department arrest report, incident report, are there direct quotations made by the defendants about Miss Bebo's conduct?
Yes.
Do those direct quotes about Miss Bebo's conduct find their way into the probable cause statement for the first arrest?
They're not in the probable cause statement.
Thank you. Mr. Presiding Officer, I move for the admission of exhibits A and B for identification as the next two exhibits, please.
I'm sorry, are you moving to admit them?
Yes, ma'am.
They're not redacted. I think there's some personal information that's contained in them that.
All right, I think A is redacted. I will redact the second one before.
Okay, so those will be admitted, subject to a redacted form going in, okay?
If I
Can
can
you-
point out, I pulled the staple off of Exhibit A, it's last
Okay, so
page is
you
trailing.
can you just give them to the court reporter, please, and she'll mark that as exhibit,
21 and 22.
that's exhibit 21 and 22.
One on the screen is 21. So I'm asking the question, is that 21?
A for identification would be 21, and B
Thank you
for
very much.
identification.
That one,
And that's on the screen.
I don't have them, so I don't know
Okay.
what to say.
Ms. Bourgeois, the statement that's on the screen, was that the document that was marked A for identification or B for identification?
That is the last page of A for identification.
Okay, so that's going to be exhibit 21. Thank you.
Mr. Travis, why does it matter whether scandalous or salacious comments are made part of the probable cause statement or the public record? Why does it matter?
There is very specific rules of professional conduct that have been provided by the SJC for attorneys and particularly for prosecutors that limit the information that should be published in advance of a case being presented in a trial in order to protect, in a criminal case, particularly a person's right to fair trial.
So are you saying there's a specific rule for prosecutors?
Yes.
And what rule is that?
So prosecutors fall under Rule 3.08, and all attorneys, including prosecutors, fall under 3.6.
And those rules that govern attorneys' conduct and prosecutors' conduct, do they apply to policemen? In other words, I guess I'm not asking well. Can a policeman make a statement or use a statement that a lawyer prosecutor can't?
No, under 3.8, a prosecutor's affirmative duties run to the people that support the prosecution, including police officers.
And is it appropriate, and when you're in your guidance and counseling situation, to tell a police officer, don't put that in a report?
Yes.
And would it be appropriate to say, well, I can't put it in the report, but you can?
Would it be appropriate for me to tell someone that I can't put it in? But no, we share a common duty under 3A to respect the defendant's right to fair trial.
And what happens if you don't take steps to protect the right to a fair trial and a witness claims that that right has been jeopardized? What are some of the potential consequences of not complying with the rule?
Objection, Your Honor, it's fine for speculation.
No, that's overruled.
So I personally have had experience in the last 2 to 3 months where a motion for a change of venue was brought by a defendant in a death case where they claimed that the extraordinary media attention around the death of a firefighter would impair their ability to have a fair trial in their home venue. And they would look for a change of venue to another county. Commonly, it's to get as far away as possible from the media attention. And that would require that a case be transferred and all the parties and witnesses associated with the case be moved to another county. The judge that's tracking the case might be following it to another county. And the jurors would be traveling back into the home county to view a scene where an incident occurred. We call a view. It's a tremendous tax on the resources of the court. And most crucially, it runs to the defendant's right to fair trial. So if that right's been substantially impaired, then their ability to get justice has been impacted. So they can seek whatever remedy they want, but a change of venue would be common.
Have prosecutors and lawyers been charged and prosecuted with violations of rules 3.6 and 3.8 to your knowledge?
Yes.
Now, before we focus on the specifics of the events in October, just a couple of questions. Did you have any role in communicating in any way with the Massachusetts State Police about the Bebo arrest?
No.
Did you ever have any communication at any time during October of 2007, the events that we've talked about in this case, communicating with Judge Bebo, Ali Bebo, or Ali Bebo's lawyers?
No.
Did you ever ask anyone to prepare a new or different arrest report?
No.
Did you know that the state police were preparing a revised report before you got it?
No.
Did you have anything to do with Trooper Ryan Screvor other than receiving a report from him?
No.
Did you listen to Trooper Screvor's testimony?
Yes.
Did you have any involvement in any of the events that he talked about?
No.
Did you even know that those events were occurring at the time they were occurring?
No.
All right. Last thing before we get to the specifics. I want you to tell us, if you would please, what specific things you were working on. What was going on in your life and your office during the weeks that included October 16, 17, 18, 19, and 20 in 2017? What were you working on?
So I was really busy. I had my own load of cases. I was supervising active homicides that week. There had been a homicide that had recently occurred that I was meeting with the state police about. I have a particularly complicated murder that I'm still prosecuting, that I had meetings with regarding a particular witness that week. I had meetings on a confidential informant that someone wanted to talk to me about. I had meetings on budget. I had a meeting on an unattended death that was very complicated that week on the 19th, and I know I was doing a record review in preparation for that meeting. That case involved an overdose that occurred in a hospital in an emergency room in Worcester County. The facts were very troubling and certainly troubling to the family we were in communication with. I was a young person that had gone into an emergency room to get into a rehab. And that person was medically unstable when they went into the emergency room, and they were intoxicated. They were kept in an emergency room for hours and hours while they were being treated and while they were trying to seek a bed for that person. And the evidence from the investigation indicated that the person, that's the person that was inpatient, called and got a delivery of narcotics to their emergency room area where they had a bed. They, from the evidence, appeared to have consumed the narcotics, overdosed. There was medical intervention, and they died in hospital after receiving drugs. We had state police meetings. I worked to get a toxicologist to look at the medical records of treatment and from the death. We had a meeting with multiple doctors at UMass Hospital with the state police that week on the 19th. I was doing all the other things that I've talked to you about I was doing that week, and in reviewing Superior Court matters that week. I know I was particularly involved with a child abuse case that prosecutor had been working with us on over the course of months, but particularly on the morning of the 17th, she sent me a long memo about it. And that memo.
What was that case about?
So that was a 7-year-old boy from Worcester County who had been abused, neglected, starved, dehydrated. He was 7 years old. He was 38 pounds in weight.
38 pounds?
38 pounds. He had burns on his feet. He had cuts on his feet. He had bruises all around his body. And he had brain damage as a result of the abuse. He was nonverbal. Initially, he was in a coma, non-responsive, ventilated. His improvement did not include speech, did not include ambulating. He didn't have balance, and he was in what would be expected to be a lifelong impact from that. A child, like a lot of children that are in that situation, are around multiple caregivers. In this particular child's case, he was not in mom's custody, he was in dad's custody. Dad had a girlfriend. The girlfriend was occasionally in the position of a parent, in a position of discipline. She had children, and there was a mother that was a non-custodial parent. So a very complicated case of abuse with difficult issues of evidence, trying to prove it. There was a conversation about whether we would try it or try to resolve it. And I worked on the case significantly over the course of that week and ultimately spoke with the district attorney on the 20th about that case. And it was a case that was troubling to the ADA that was immediately handling it, to myself and to the district attorney.
So just so that we put that in perspective, the 17th was the morning of the arraignment for Ali Bebo, right?
Yeah, sometime after 10 o'clock.
And the 20th was the day that you had the conversation with Mr. Keenan.
That's right.
And just so that I don't mistake myself, were you in the courtroom when the Ali Bebo case was called for arraignment and Judge Locke dealt with the impoundment issue?
Not at all.
Did you know about it at the time?
I knew she was coming in to be arraigned. It turned out she wasn't arraigned, and I got some text messages about that.
When you heard about the Bebo arrest, were you surprised?
Not really. She was a young person that had troubles.
And you knew that from what context?
So she had the prior arrest, and her demeanor generally, with the limited occasions I'd had contact with her, she seemed emotional.
Did you review any of the paperwork when it came in?
For the Ali Bebo case, after it came in, at some point, either the prosecutor handling the arraignment or one of her helpers ran some copies from the file to me.
Was there anything in the paperwork that surprised or troubled you?
Yeah, yes, I read the police report fairly quickly. It was a woman in a bad medical state. The evidence was troubling, a person that couldn't sign forms, that kind of thing. But particularly, there were 3 statements that jumped out at me.
And what was it about them that jumped out at you?
So, we talk about 3.6 and 3.8, and the whole police report versus a probable cause shorter report. There were 3 statements that were in there. There's the statement, my effing father's a judge and he's gonna kill me. There's the suggestion of sexual acts for lighter treatment. And then there's a quotation that's attributed to her regarding sex acts to purchase narcotics.
And in what context did those concern you?
So anything in quotes under 3.6 doesn't go into a statement of the case, to my mind. Doesn't quote.
Judge, can I just ask Mr. Travers to speak up just a little bit?
Apologize.
Sorry.
To my mind, anything in quotations, an attribution, admission, a confession, quoted statements should not be in a public statement of the case before a person's had a right to counsel or a judicial officer, a judge review that information before it's put in against them. So the statement about anything in quotation, really, to my mind, didn't go in there. The statements about, leniency, sex for leniency, frankly, that could go into a police report, didn't belong in a probable cause report. It was a summary of a statement, which is certainly better than a quotation. The statement of my father's an F and this, and he's gonna kill me, to me, that belongs in a report. If it's gonna belong somewhere, it does not belong in a public statement before someone's had a right to counsel or a judge. It's a quote, it's highly prejudicial, and put it in the police report if you're gonna put it somewhere. The statement about sex acts to secure narcotics for herself and another, that I don't understand. It's a quoted attribution that does not belong in a probable cause statement. Frankly, none of these statements are coming in an OUI trial, in my trial
Use
experience.
the phrase coming in,
They're
explain.
not coming into evidence. If a judge applies a balancing test as to the probative value of those three statements against their prejudicial weight in front of a jury, none of those are coming in.
And is that the test a judge normally uses?
Yes. Absolutely. So there's that concern for it. And when you think about probative value, the tendency to prove an element of a crime, the probative value of I did this sex act to get drugs from me and this person is low. It's not going to be admitted into evidence. It's a quoted statement that should not be in a public statement of facts or probable cause statement. It also describes activity which is independently potentially criminal. Just like offering sex to someone to get out of trouble is potentially criminal. So can you make an argument that it has anything to do with an ODI? Maybe. But if you're talking about trying to influence a public official, there's a felony for that. And it's not charged. So if you're gonna put it somewhere, you put it in the police report and people can argue about it later. The thing about, I did this to get drugs. Well, that relates to at least a couple of offenses that people have talked about here. Prostitution, human trafficking, that's someone, deriving something from another person for sex trade. And then there's, a person that is living off of the proceeds of prostitution would be a third thing I could think of. If you're thinking about those kinds of offenses, putting aside the quotes that didn't belong there, putting aside they're not coming into evidence, that's someone who is potentially either committing a crime that you're now detailing publicly without charging it, or they're potentially the victim of a crime, human trafficking or the like. And if that's something you're even considering investigating, first, people that are the victims of sexual acts are statutorily protected from being identified in a police report. Second, if you're thinking about charging, in a misdemeanor OUI, a felony, human trafficking, you wouldn't identify the victim publicly in a police report. First, you'll have destroyed any goodwill or opportunity to investigate because you've lost their cooperation. Second, you've put them in harm's way by publicly identifying them around people that are bad doers, people that are taking advantage of and putting women typically at risk. I felt those three statements did not belong there.
And in taking steps to eliminate those statements from the public record, were you trying to do any favor for Judge Bebo or his daughter?
Absolutely not.
Now, were there any discussions with anybody in the office, including Mr. Early, about anyone trying to do a favor for Judge Bebo or his daughter?
Not at all.
Now, tell us about your early involvement with the case, the first things that you did and the steps that you took in terms of communications, decisions that had to be made.
Sure. Well, we talked a little bit about, I'm in touch with people about cases 24/7. The first things I remember about this were at home, I'm getting some text messages about the fact that you've been arrested and trying to figure out where this case is gonna come in. So what courts are gonna end up in? Is it gonna be today? Who's got the police reports? Those kinds of things. So there was, questions around what court, who, when's it gonna come to court? And I recall finding out that it was coming into Worcester. that she initially wasn't going to appear, giving me the impression that they'd be a default. Then subsequently that there was an attorney appearing. I got a text message from an ADA in the arraignment session asking me if we'd agreed to continue the case if a lawyer's in court and she's gotten into a secure treatment detox or the like, and indicating, yes, we'll do that. That was day one of the kind of the information flowing to me.
Before we leave day one, did you know in advance that there was going to be a motion to impound the probable cause statement?
No.
How did you learn about it?
So at some point, when the file material started filtering from the arraignment session to me, I believe it was among the documents that I received.
And did you have any concerns about the impoundment?
So the impoundment, back earlier in my career, that would have been okay. After the Uniform Rules of Impoundment, no. That appeared to me to be a motion that was inadequate. It wasn't supported by an affidavit. They didn't provide, and the judge didn't make a specific findings. It appeared to be endorsed as allowed without limitation, which to me meant it was indefinitely impounded. Those were some of the things that jumped out at me. We typically use kind of a boilerplate almost motion, where it's a motion, affidavit of counsel, proposed order for the judge. This didn't look to be any of those things, and it had the effect of just impounding everything. So the public would have no idea of the factual basis for those charges. Where, again, with the changes with the Uniform Rules of Impoundment, there is a more favored approach to limited information being impounded.
Mr. Cantorowitz, could I please have, to show the witness, Exhibit 17A, and also publish it to the other commissioners, please? It's the Roberta O'Brien statement. And Mr. Shah, can this be published to the? Mr. Travers, document that has been published as Exhibit 17A, it's fairly brief. I'm going to ask you to please read it into the record if you would.
Sure. The document has no header. It begins number 1. My name is Roberta A. O'Brien. 2, I am an assistant district attorney who handled the hearing on the Commonwealth versus Ellie Debo in Worcester District Court on October the 17th, 2017, before Judge David Locke. 3, at the time of the hearing, I understood that Judge Locke allowed a defense motion to impound, but only until the next court date for the case. 4, I now know that the written motion, the judge's handwritten allowance of it, and the court's docket entry all show no time limitation for the impoundment. 5, on October the 17th, I delivered the file with the motion as endorsed by Judge Locke to Assistant District Attorney Jeffrey Travers for assignment. 6, Mr. Travers was not in the courtroom when the hearing took place. 7, I do not recall having a conversation with or otherwise informing Mr. Travers or any other employee of the Worcester District Attorney's Office as to any time limit on the motion to impound. Subscribed and sworn on the penalties of perjury this 28th day of March 2022, signed Roberta A. O'Brien, Exhibit 17H.
And my question for you, Mr. Travers, is when you received the materials, the case file, and the motion and materials from Roberta O'Brien, what was your understanding of the duration of the impoundment order?
It appeared to me there was no time limit on the impoundment order. It simply impounded everything without limit.
And did that understanding ever change up to years later when you heard the recording of the session in front of Judge Locke?
So I've heard different information that the recording actually indicates an intention to terminate the order at the arraignment. I did understand that to be true. but I didn't know it at all back at this time.
Okay, and at the time you were talking to Mr. Keenan, what was your understanding?
Just that it was all impounded permanently.
Now, after you got the materials on the 17th, did you have any further involvement with the Bebo matter?
So I recall photocopying the arrest report that was provided with the complaint forms that states the charges, put it in an envelope, and I either handed the envelope to District Attorney Early or gave it to his administrative assistant. At some point, I passed them in a common hallway, and I made some statement that I'd left the report for him, that it was bad.
You said it was bad.
Yeah.
Did he say anything in response?
No, not that I recall that occasion.
What was the next thing that happened on the Bebo matter?
So sometime subsequent, I know I had a conversation with DA Early, where I expressed that I thought, we'd send the case to a special. Certainly, I don't think there was any disagreement about whether we'd send it to a special.
Again, you're talking code. Send it to a special. What does that mean?
Apologies. Send it to a special prosecutor, someone outside of the Worcester DA's office who would handle it. My thought initially was that perhaps the attorney that had handled the case from Northern Worcester County might accept this case like the previous one. And I believe on the same occasion, the DA indicated a preference that it go out of county to Essex County.
Essex County.
Yes.
And at that time, did you or he know what Judge Dawley's decision would be about where the case would go, the court file would go?
No.
And were you able, or was your office able to make a decision about what special prosecutor to use, if any, before you knew where the case was going?
No.
And what was the next thing that happened?
So that was all, let's see, the 17th, the 18th, I don't recall anything occurring with the Bebo matter. The 19th, I was occupied with that case I described where I had a meeting with the toxicologist and the state police. Sometime, I believe it was the afternoon of the 19th, I recall having a brief conversation with the district attorney by telephone.
That would be Mr. Early, right?
Yes. I believe I was traveling either to or from that meeting at the hospital, and I got a brief call saying the state police are delivering a report in the Bebo matter. And I said, okay, and hung up.
Okay. When you say, and he said the state police are delivering a report, did you know what kind of report it was?
No.
Do you know what the subject matter of the report was?
Just the Ali Bebo case.
Did you assume or believe it was a revised arrest report?
No.
What happened next?
Then shortly after or after that conversation with District Attorney Early, I recall I got a text message from First Assistant Edward Carcasinas indicating that the state police wanted to drop off a report and that he had said to leave it for me. I indicated to him I'd be back in about 15 minutes because, again, I think I was traveling. I recall being in my office working on other things and someone coming in and saying to someone at the counter they'd like to see you. I recall going out, seeing a young trooper who I hadn't met before, who indicated he had an envelope with a report for me. I shook his hand, I said thank you, he gave it to me and he left.
And was that person Trooper Scrivener?
I believe so, just from the circumstances more than anything else, to be honest.
Now, before we proceed further, do you know why the state police were directing the report to you?
I assume because I handle every special prosecution, so if there's any information that's coming in, it's gonna be funneled through me, so I make sure I don't leave something out that's gonna be leaving the office going to that specially assigned prosecutor.
Okay. And when you got the new document, what'd you do with it?
So it was in a sealed envelope. I took the sealed envelope, I put it on the corner of my desk and I left it there because I had a lot of other things going on. I just didn't get to it.
Did you look at it?
No.
Okay. What happened next?
So I worked that day on other things. The following day was the 20th. At some point, I recall getting a call from the district attorney early, saying that he wanted me to see what's going on with the Bebo case, or words to that effect. So after I hung up the phone, I said, okay. So after that, I opened up the envelope that I received the prior day that was sitting sealed on my desk.
So what exactly, as best as you remember, was it that Mr. Early said to you in that phone conversation?
I think he had said that he had spoken to a judge and he wanted me to go speak to the clerk and find out what's going on with the case.
To find out what's going on?
Yeah.
Okay. And you then did what?
So then I open up the envelope that I didn't open up the day prior, and I see what's in the envelope. There is an application for a criminal complaint form that I believe is 3 pages long. It's pre-populated with information regarding the case that I believe is pending upstairs. And underneath it is a police report. It's all caps, centered, revised, the date prior, October the 19th, 2017.
Okay, now, before we go to that, you said there was another form that was pre-populated. Was that something that was automatically printed out?
I believe that's what happens at the state police when they use their RAM system. As part of the printing of the report, it sends out this form that the court uses, which we've referred to as the application for complaint.
And would you look at exhibit number 2, please? We have exhibit 2. Thank you, sir. And is exhibit number 2 the revised report that you got?
Yes, this looks like it.
Okay, and focusing on, I think it's the second page, the arrest narrative section. Did you see some words at the beginning, at the top of the arrest narrative section?
I'm sorry, could you redirect me which section of the report?
It's the part that's called arrest narrative. It's right here, okay?
Yep, got it.
Okay. And that's a separate section of the document. Is it?
Yes.
And tell us what is printed at the very top of that section.
So all caps, centered, revised on October 19, 2017.
And did you see that language when you read it?
Yes.
And did you feel that that identified the document as something that had in fact been created recently?
Revised on that date.
Okay. In your subsequent discussions with Mr. Keenan, did he ever look at that document to see that legend revised on October 19, 2017?
No.
What was the date of the probable cause finding?
I believe it was on the 7th.
That was 2 days before the document was revised, is that right?
Yes.
Can you think of any way that anyone could look at that document and think that it was the document on which probable cause was based?
Objection.
No, you can have it.
It clearly indicates it's a revised document that was generated after.
And so were you concerned that anyone looking at the document might think that you were doing something wrong?
No.
What did you do next with the document?
So I saw the application for complaint forms that have been described. Those, I think, run 3 pages. And the 4th page would be the statement of facts, and this is where that would reside in the file. So I look at them, I went upstairs to see the clerk, as the DA asked me to do, bringing what was the revised report with me.
Okay, now this is 4.5 years ago, but did you, when you met with Mr. Keenan, was it Where did you meet with him? Was it a public space, his office, door open, door closed, door open?
Sure. So it was behind the counter of the clerk's office in the court personnel area where people that work in the courthouse go to interact with the court. The state police trooper has a space back there who brings in reports. I went to the back. I know where his office is because I've sat with him on search warrants and other matters previously. And his door was open and I asked if I could speak with him.
And tell us your best memory of the conversation, what you said and what he said.
Sure. He invited me in. The door was open. I sat down. I think I said to him, I was hoping to talk to him about the Bebo matter. I said something to the effect of the police report in that matter was very troubling. It would be upsetting for any family. And I was very concerned, particularly about the defendant's right to fair trial because of the potential of those same troubling statements to prejudice her if they're put out to the public in a public statement. I let him know that I'd received a revised report from the state police, and I wanted to know if I could offer it to him.
And is that your best memory? Did you ask him if you could offer it?
So I don't know if I think I said I wanted to know if he could accept it. If I didn't say accept, I would have said offer.
Was there any discussion with him or any suggestion by you of swapping out the reports or substituting the reports?
No, he never took the report, and the original report was impounded by a judge.
And at that point, had you even seen the report?
No, and that's true. I hadn't seen it. I didn't know what the content of it was.
Well, you knew it had been impounded for a reason, though, correct?
Yes.
Now, once Mr. Keenan said he couldn't accept the report, what happened in the conversation next?
So he specifically suggested you could move to redact the original report. And I thought about it for a minute, and we talked about, prejudice and what would be the effect of the case. It seemed like a solution to cure that potential for prejudice. I said, it sounded like a good idea, that I would be willing to bring a motion to redact the original report. He indicated, well, we could see if there's a judge available that you could bring the motion before. And he invited me to wait out in the public area on the floor above, where his office is on the second floor, outside of the judge's lobby. He traveled behind the scenes up to the judge's lobby and then came and invited me in after a few minutes.
Okay. Now, Mr. Keenan, we hear from Mr. Keenan's testimony.
Yes.
He said that he went in to see the judge and the district attorney, Mr. Early, was there on another matter. Did you hear that?
Yes, I heard it.
Okay. Did you know anything about that?
No, I didn't know anything about it, and it wasn't going on when I went in.
Okay. In fact, when did you learn about that?
I think when I read about it in the discovery material.
In this case?
Yes.
Okay. So after he came back from Judge Despotopoulos, please take us through the sequence of what occurred with the judge and what you did in terms of the redaction.
Sure. So he brought me into the judge's lobby. In the judge's lobby, they have a law library with a conference table. Judge Despotopoulos was already in the room. Brendan Keenan brought me into the room. The judge seemed to be aware of why I was there. And he indicated in substance that the report he was aware of and that it had a lot of material in it that was prejudicial. He asked me what I wanted to do. I indicated I wanted to do a motion on the record to redact the probable cause statement that was in the file. He said, that's fine. I said, well, I'll have to notify counsel for the defendant and get the motion into court to present it. He indicated that the defendant was not represented, that she'd been represented for arraignment only, but that motion could be brought ex parte before him that afternoon. And I said, okay.
Okay, for the benefit of those of us who are lousy in Latin, what does ex parte mean?
Sure. So when one party brings a motion before the court without the other side potentially present.
And did you in fact do that?
Yes.
And Ms. Duca, could I please have exhibit number 9, please? Should be a transcript of the hearing.
I think it's this.
I think that is it, yeah.
Is that it?
Pardon?
Is this it here?
I think this is, yes, we're good. Okay. Mr. Travers, do you recognize what's been marked as exhibit number 9? Stipulated exhibit.
Yes, it appears to be a transcript of the hearing in which I presented the motion to redact.
Okay, what I'm gonna ask you to do is just the very first section on that. I'm gonna ask you to read that slowly into the record, would you please? This is your words being spoken to Judge Destatopoulos, right?
Sure. Travers, Your Honor, in the matter of 1762 CR 8064, Jeffrey Travers, on behalf of the Commonwealth, Your Honor. Your Honor, the Commonwealth would ask, inaudible, brought forward and would offer a redaction to the probable cause statement in the case. It's my understanding that as well as the file was recently impounded in the matter. The Commonwealth would suggest the redactions which I hand up are appropriate, given the Commonwealth's ethical obligations to avoid unnecessary pretrial publicity, which would be prejudicial to the defendant. I would suggest to you that the statements are extraneous to anything applied to the finding of probable cause and really are purely prejudicial potentially to the defendant.
And what did Judge Destatopoulos say?
The court, okay, I'll allow that.
Thank you. Okay, well done with that, thanks. And just, you've already talked about the 3 areas that you redacted. Are they the same 3 statements, is that correct, that you described earlier?
So they're somewhat less than complete sentences. When I looked at it, I just took out the quoted words. I left the balance of the sentences that were surrounding the quote. I wasn't looking to erase entire sentences or lines, just the quotes.
At the time you were making the redactions, did you focus on what had been removed from the revised state police report to see if they were the same?
No, I had those lines in my mind as being most problematic because the first one elevated the potential for media to focus on the case, and the second 2 were the most concerning.
Okay. After the fact, did you ever make a comparison of what Trooper Screvor had removed from his report and what you had redacted to compare the 2?
Yes.
And how did they compare?
So in his report, there are entire sentences containing quotes or attributions which were removed. If you looked at that report versus the original one, you wouldn't know that the initial sentence containing the attribution was even in the report. If you look at the redactions I did, I took out the exact language that was attributed to the defendant, leaving the rest of the sentence. So you can clearly see there are limited areas that have been removed that were attributed to the defendant.
So he redacted more than you did?
Yes.
Do you know what happened to the original unredacted report?
Well, I heard Trooper Scavor overwrote it, but I had a copy of it that was originally filed with my office. We heard that the trooper communicates 2 copies of the original report to the court, which are not public documents, but are disseminated to counsel. So I had received a copy of the original unredacted report, which I preserved and put a Post-it note on.
Before you tell me that, I want to know when in time you did this. Was it before there was any publicity in the case?
Absolutely, it had to be a couple of weeks before, I would guess.
So before there was any publicity in the case, tell us what you did with the original report that you had.
So when I was in the process of trying to communicate the material that would support the discovery in the case, to ship it to the prosecutor in Middlesex, as it turned out, I put together an envelope. I put the original police report in it, that it was filed with the court, with the criminal complaint. I put the revised report that was delivered to me, and I put the original unredacted probable cause statement, all three things. Attached to them, I put 3 separate Post-it notes, one indicating this is the original police report in the case. A second one indicating this revised report was delivered to me on 10/19/2017. And then a third Post-it note on the third item that was in the envelope indicating this is the original unredacted probable cause statement, and indicating that I had made redactions because of the prejudicial content rather. I placed them all into an envelope. I sealed the envelope. I taped the envelope. I brought it to a lieutenant with the state police that works in our state police detective unit. I asked him to hand carry it to the special prosecutor in Middlesex. I signed the seal where I had taped the envelope closed to show that it was sealed under my signature that day, and those items were hand-delivered.
Including the original report.
Including the original report.
Good news is we're getting near the end. Mr. Travers, I want to read to you 2 paragraphs of the order to show cause against you in this case. I'll ask if the statements made in there are true or false. Paragraph 12. Early directed Travers to go to the Worcester County District Court Clerk's office and replace the original report of the daughter's arrest with the revised arrest report.
That's a false statement. It's not true.
Number 13, Travers went to the clerk's office and attempted to replace the original arrest report in the court's file with a sanitized revised report. Is that true?
It's absolutely not true.
Let me ask you just a couple more questions. When you got the new report in the envelope, why don't you just throw it away? Toss it in the bucket, why not?
So my obligation is to preserve everything. And I felt that that was a document that went to the probable cause because it was attached to a probable cause application, and that had been revised. That's why I didn't throw it away. I thought it had some significance.
Why'd you take it to Mr. Keenan?
Because it was attached to a probable cause application.
Why didn't you just put the document in the file and let the next prosecutor deal with it?
Well, first, I would never pass the buck to another prosecutor. I felt that I'd received a revised document that was linked to the original probable cause statement, and that I should at minimum bring it to the clerk's attention.
Did you ever discuss with Mr. Early or anyone else in the district attorney's office what to do with this revised report?
No.
Did you go to the clerk's office with some plan or mission to swap reports?
Absolutely not.
And when Mr. Keenan said he couldn't take the new report, did you argue with him? Did you push back? Did you try to talk him into it?
No.
If you had wanted to proceed without involving Mr. Keenan or a judge or anything, just on your own, to proceed on just the new report, was there a way to do it?
Yes.
How was that?
So under the separation of powers, a prosecutor is the executive branch of government, can terminate and dismiss a prosecution independently on our own authority. As the first assistant, I am the only one under the district attorney that has that authority. I can file a single-page document with any clerk's office terminating a criminal prosecution. The case would be over. It would have been subject to the impoundment order of the court. I could have filed the new application for complaint with the new report, and it would have started with the new document.
You didn't do that, did you?
No, I wouldn't have had to talk to the clerk, the judge, anyone. It's the separation of powers issue. I had no intention of doing that.
Lastly, what do you say to the question or the statement made by Trooper Screevor that none of this would have happened if it wasn't a judge's daughter?
It's a broad statement. I suppose there wouldn't be any concern for pretrial publicity of the order that there was in this case, and as was realized, if she wasn't the daughter of a judge in a drug court with that attribution of the statement about her effing father. So that was the gasoline, to my mind, that would fuel prejudice associated with the content that was placed in that public probable cause statement.
And did you say that it was a drug court?
Yes.
And she was charged with being a drug addict, and her father was the judge of a drug court?
Yes.
In your mind, how would that accelerate publicity?
It's a substance use disorder that she appears to be struggling with, that she's charged with, that the family is engaged with working through the criminal justice system with people in that same position.
Nothing further, sir.
Okay, thank you very much. Before we start the cross-examination, I'll just take a short break, perhaps to collect your thoughts, about 10 minutes. How long do you think your there's no limit, for planning purposes. Are you going to do the cross-examination? You are, Ms. Morong? Okay, and about how long? And I'm not going to hold you to it.
I think it will be brief.
It'll be brief?
Yes.
Oh, okay, well, okay, thank you. Okay, we'll take about a 10-minute break and then we'll be right back. Thank you. The floor is yours.
Thank you, Commissioner. Good afternoon, Mr. Travers.
Good afternoon.
I'm sorry. 2 seconds.
Okay.
Sir?
Thank you.
You okay? Okay, good, thank you.
Sorry.
No, quite all.
All set?
Thank you, sorry.
Sure. So, Mr. Travers, you heard about the motion to redact that was allowed on October 17th. You became aware of that on October 17th?
I think you mean the motion to impound?
Thank you. Strike that. Mr. Travers, you found, did you learn about the motion to impound that was allowed on October 17th? Did you learn that on the same day?
So it's very difficult to say, given the passage of time. That's my best estimate, as I probably learned at the same time I received whatever papers I received on the 17th.
And the papers that you received, did they include the arrest report and the criminal complaint application?
No, so what the district attorney's office gets is the full police report. In this case, it was the arrest report, the drug recognition report. I believe there may have been breathalyzer information on a reading, DRE report, the Miranda form. And then what we get is a docket sheet, which is the listing of charges without the notations that are entered by the clerk or the initial application document, which would have contained the statement of facts. We don't receive those materials.
And anything in that paperwork, did it indicate what the next date would be for this case?
I don't recall.
And I believe you testified on direct that you thought that the motion to impound was inadequate, in your words?
So the motion to impound, yes. I thought it had issues.
Okay. But you took no action on the motion to impound on October 18th, is that correct?
On the 17th, I took no action, nor on the 18th.
And you took no action on it on the 19th either, correct?
No, I did not.
You were very busy that week, correct?
Very busy.
You had spoken on direct about a number of different, very important matters that were going on that week, correct?
Yes.
You did take action once you received the revised Mass State Police report, correct?
No.
You didn't?
No.
When did you take action regarding the motion to impound?
I didn't take action regarding the motion to impound. The court lifted the motion to impound on the 20th.
And they lifted it based on your motion to redact, correct?
Well, actually, I made a motion to redact, and I think subsequent to that, the court both unimpounded sui sponte and then sealed the original sui sponte, what the clerk did.
But there was nothing that prevented you from filing a motion to redact on October 18th, was there?
No.
And there was nothing to prevent you from moving to redact the statements on October 19th, correct?
Other than time, no.
Instead, you waited until you got the revised report and then you filed the motion to redact, correct?
Actually, I received the revised report on the 19th. It remained sealed in my office overnight until the following day of the 20th. Then it's sometime in the afternoon of the 20th.
And you've stated on direct that you were very busy that week with a number of important issues, correct?
Correct.
And yet you brought the revised report personally down to Mr. Keenan's office, correct?
That's correct.
And you sought his guidance regarding this revised report, correct?
Yes.
And you listed, you went through all of the experience that you've had in the district attorney's office, correct?
As best I can remember.
And I timed it, and I want to say it was about 20 minutes, and it was very impressive. And since being in the district attorney's office since 1998, you've seen a lot of cases.
Sure.
And I think, I wrote down, you think Worcester, is it the district court that sees 9,000 cases a year?
That's pretty much an average,
And that there are 80 prosecutors there.
roughly.
And as the senior first assistant, you supervise all of those prosecutors.
Yes.
And in all of that experience, you needed to go see Mr. Keenan for advice on what to do with this revised report.
Correct.
And you didn't bring a motion to redact to Mr. Keenan's office when you saw him, correct?
No, he suggested the motion.
And you didn't bring a redacted version of the arrest report with you, did you?
Redacted version, no.
You brought the revised arrest report with you when you went to see Mr. Keenan, correct?
Correct.
Just one moment, please. I have nothing further, thank you.
Thank you.
Okay, once again, I just from a fellow commissioner who has some questions, and I'll just read the questions to you,
Yes, sure.
okay? How many OUI cases did you get involved with in 2017?
OUI. So I was handling a operating under the influence impairment drugs case, I believe in 2016, that resulted in the death of Trooper Clardy.
Okay, any other OUI cases that you were involved with in 2017?
So I was supervising every operating under the influence that resulted in a death, so I'm sure I was involved. And every motor vehicle fatality, which unfortunately many of them involved deaths. So I'm sure on some level I was involved.
Okay. How many police reports for OUI cases have you moved to redact?
The OUI. So I've moved to impound reports in motor vehicle homicides impaired resulting in death. I have not moved to do so in strictly OUIs unless, well, yeah, I really wouldn't handle that kind of a case unless there was a death or it was special.
Okay. Okay. When you went to Clerk Keenan with the revised report, What did you expect might happen?
So I didn't have any expectation. I had a application for complaint with a revised statement attached to it that I thought I should bring to his attention to find out what he thought. Any guidance he could provide, what I should do with it.
Okay, and lastly, do police reports often include inadmissible evidence?
So specifically, Rule 3.6, and by extension 3.8, indicates that evidence which is reasonably has admissibility issues should not be contained in statements to the public. Likewise, information that would go to a person's reputation, bad character, or call condemnation, a public condemnation against a person. None of those things should be in public statements.
Okay, and a few more. Did DA Early mention what was being delivered by the state trooper?
Only a report.
Only a report, okay. Have you been involved in prosecuting other criminal matters involving judges' family members?
I handled one special prosecution that involved another judge's child, and I don't know if it was a case of domestic battery or something like that.
Okay. Ms. Burke, do you want to ask any questions?
Sir, good afternoon. Was your decision to go to Clerk Keenan's office predicated upon whether or not you had done this before in other OUI cases? Or did it relate to your responsibilities as a prosecutor under Rule 3.06 and 3.08?
So it directly came from 3.6 and 3.8, and the fact that it was my responsibility as the first assistant to deal with that special case.
And does your stature as the senior first assistant district attorney dictate whether or not you would be involved in this kind of motion to redact? Did you have a specialized responsibility based upon your senior status and experience?
So anybody in the office could bring motions. I had to deal with this particular case because it was headed to a special prosecutor.
So the facts are, it's being sent out because there's a potential conflict by the district court by the district court judge who supervises these issues. Isn't that true?
That's true.
That's Judge Dolly, right?
That's right.
So independent of what you're doing or not doing, the case was being sent out of Worcester County to another county.
That's absolutely right. And our intention was, if it hadn't been, we would have had another special prosecutor handle the case.
And was there a special prosecutor appointed to this case?
So yes, initially, Essex County's first assistant indicated that they would come in and prosecute the case. Then subsequent to that, I received the transfer order, which sent the case to Middlesex. We had a conversation that it just made more sense for Middlesex to do it.
Can I just back up for a minute? So the first assistant in Essex was going to do this?
So they initially were willing to accept it as a special prosecution until they found out it was going to Framingham, and then really it made more sense for the Middle District to handle it. Okay. Middlesex, rather.
If you had assigned it to the most junior member of your staff, would you be criticized for having somebody inexperienced do this?
We always feel like, things need to be done with some methodical protocol, and that's the reason it's done that way. Predates me.
Sir, thank you very much.
Thank you.
Appreciate it.
Kylie?
Good afternoon, Mr. Travers.
Good afternoon, sir.
As a first assistant district attorney, somebody had to educate you on Rule 3.6 and 3.8, did they?
No, sir, I keep it in my office.
The professional rules sit on your desk or in your office?
They do, sir. We commonly rely back to them, particularly when making media comment.
You handle all of the cases that are going to be specialed, correct?
That's right.
And those cases are specialed because of conflicts in many instances, correct?
That's true.
And when you speak of conflicts, you're not necessarily speaking about just things that are covered by Chapter 268A, correct?
That's true.
There are conflict of interest provisions within the rules of professional conduct, for instance.
Yes, sir.
And in your office, well, strike that. You were aware that District Attorney Burley had been a defense counsel for many years before becoming district attorney, correct?
Yes, sir.
And so did you handle, during your tenure as first assistant, a lot of cases where there was a conflict simply because of prior representation
Yes, sir.
and involvement with lawyers?
That's true.
You used the phrase Minister of Justice, correct?
Yes, sir.
That is a phrase that is in the comments to the professional rules, correct?
Yes, sir.
And as a Minister of Justice, you understand that a prosecutor has duties to a criminal defendant, correct?
That's true.
And those duties conflict with the duties that he has or she has to prosecute the case diligently, correct?
Absolutely.
And it is a prosecutor's duty as a Minister of Justice not to strike foul blows, correct?
That's true.
That's what the case law and the pronouncements from on high say, correct?
That's right.
The rules prohibit not just things that relate to character, they flatly prohibit statements attributed to a defendant, do they not?
It's absolutely correct.
So the fact that something is in quotations, if it had come from somebody else as opposed to the defendant, would not have posed the issue that was posed for you in this case, correct?
So the defendant's statements are the ones that are most sensitive.
And this particular document that you looked at had multiple quoted statements from the young lady, correct?
Absolutely.
And none of them belonged in the statement, correct?
It shouldn't be under the rules, any attribution, a quoted statement from a defendant. That's true.
And you didn't need somebody else to tell you that, correct?
No, sir.
Now, just quickly, you heard testimony here earlier about a complaint package, correct?
Yes.
And you understand a complaint package to include multiple copies going to different places in the courthouse, correct?
That's right.
And one of the places it goes is to the clerk's, if something goes, is to the clerk's office, correct?
Yes.
And that is the actual application for a complaint, correct?
Yes, that's right.
And in this case, the person who is the complainant in this case would have been Dean Ricciardi, correct?
That's right. It's the court officer.
It's not the trooper himself.
That's absolutely right.
And you are aware that the clerk magistrate finding probable cause was authorized under the rules to make suggestions to the complainant, correct?
That's specifically provided for within the trial court's rules.
And those rules you have understood, again, based on your training as a first assistant district attorney.
That's right. Those were those 2015 rules that were in effect at the time.
A second package comes to the district attorney's office, correct?
That's right. That's the non-public reports.
What becomes public in what goes to the court after the probable cause is found is not the same as what it is the district attorney gets, correct?
That's at the crux of the entire matter, sir.
It was the wrong document that we were dealing with, correct?
Correct.
There is a third package, is there not, that goes to the probation department?
I believe that's true.
And that the probation department package, to your understanding, includes criminal offender record information.
Yes,
That criminal offender record information is also not public, is it?
not public and would be illegal to disseminate.
So in this case, what you had in your possession prior to the receipt of material brought to you by the trooper you assume to have been Trooper Sevier is the package that you had received or your office had received, correct?
That's correct.
And that would have contained more information, correct?
Yes,
And you had no discussion with District Attorney Early instructing you to do anything with respect to the packet you got, correct?
that's absolutely true.
No further questions?
Okay. Give me 1 second. Borsconi?
Good afternoon, First Assistant Travers. Good afternoon. First Assistant Travers, you referenced your extensive experience in operating under the influence charges, specifically ones that result in fatalities or serious injury. Is that accurate?
That's true.
Fair to say that not only through that, but your experience as a trial attorney in the district courts, superior courts, coming up to where you are today, you've done a few OUI trials, fair to say? You've handled a few OUI motions.
Yes,
You're pretty familiar with the criminal jury instructions.
yes,
And you're aware that the elements of OUI, whether it's drugs or alcohol, is operation, public way, and impairment, right?
that's right.
And if someone says, I used heroin this morning at around 9 a.m., preceding a crash, you'd say that's a pretty good sign or something that could use as probable cause for impairment, right?
Absolutely, that covers all the elements, but you shouldn't put it in quotes.
That's not what I was getting at, but consumption goes to impairment.
Yeah.
To say that someone admits to consuming a substance, obviously it's in their body and it could contribute to them being impaired.
Absolutely.
Does the method by which someone who has admitted to consuming a substance have any bearing on probable cause for impairment at all?
None.
Okay, thank you very much. Do you have anything on
Um,
redirect?
I do not have any redirect, but I think it's appropriate at this time to ask the commission to take judicial notice, if you would, of rules of professional responsibility 3.6 and 3.8. And more specifically, sir, the provisions of the official commentary at number 5, which if I may read it, comment 5 to rule 3.6 says, there are, on the other hand, certain subjects that are more likely than not to have a material prejudicial effect on a proceeding, particularly when they relate to a criminal matter or other proceeding that could result in incarceration. And the subjects relate to, in number 2, it reads, in a criminal case or proceeding that could result in incarceration, the possibility of a plea of guilty or offense, the existence or contents of any confession, admission, or statement given by a defendant. I think you should take judicial notice of that, particularly that commentary, 5.2.
I will take judicial notice of it. Can you furnish us with a copy of that? We don't have a copy.
I've got a copy here, and
Okay,
while I'm on my feet, I've also got the redacted exhibit 22.
okay, thank you.
These are the rules.
Okay, thank you. I'll just add that to the packet that Attorney Pinero
Thank you.
has given, is going to give us, will give us.
I can add it to the packet also.
Okay, thank you. Thank you. Okay, so,
Hearing officer, could I just follow up with one or two
Sure.
questions? Thank you. Mr. Travers, earlier, the hearing officer read something, a question that one of the commissioners had about your experience in 2017 dealing with operating under the influence. And I think you responded that you would have been involved if there were deaths involved. How many operating under the influences without a death involved were you involved with in 2017?
I couldn't say from the stand. I don't have any knowledge of how many.
And were you aware that after the actions of this matter were completed, that the Massachusetts State Police did an independent investigation?
Objection beyond the scope.
That is beyond the scope, but I'll give us some leeway, I'm giving the party some leeway.
But this is, first of all, this is opinion testimony that's being offered beyond the scope of anything that we have ever asked in our cross or redirect.
No, you're right, but I think it's a yes or no question.
It is, Your Honor.
I'll hold a tight rein with her, but it is outside the scope.
Thank you for your. Mr. Travers, are you aware that there was an independent investigation by the Massachusetts State Police?
But I object to it, a so-called independent. It's an investigation.
Okay.
That's self-proclaimed independent.
Oh, okay, so.
I'll rephrase the question. I
Okay.
withdraw that question. Mr. Travers, are you aware that there was an investigation performed by Kevin P. Burke and Nancy McGilvery in 2018 regarding these matters?
I've heard of it.
Did you ever read the report?
No.
Thank you, nothing further.
Okay.
Can I just have a second?
Sure, take your time.
Bear with me for a minute. All set, thank you.
Okay, so there's nothing, you have no questions?
Waved off, just no, thank you.
No,
No. Mr. Rusconi, nothing?
No, Your Honor.
Okay, sir, thank you very
Thank you.
much. Okay, well, that'll end the live testimony today. Where do we stand? Do we have any housekeeping matters you want to be heard on?
I want to say thank you for the courtesy that you have expressed, you extended to me in allowing me to take on.
Yeah, no problem. No.
I will be here until about 2 o'clock.
Okay, very good, thank you. Do you anticipate participating via Zoom when you're back in Arizona?
Certainly not when I'm traveling, which will be tomorrow. The answer would be yes during the respondent's testimony, but probably not in the details of the state police case.
Okay. Floor is yours.
First of all, thank you, Candice Brooke, for the petitioner. I don't think I introduced myself today. I'd like the respondents to confirm that they are not calling any witnesses tomorrow. Is that correct, counsel?
yeah, I have previously reported that I had two individuals. I've informed them through their counsel, Mr. Sullivan, that I will not be calling them tomorrow. We dealt with the matters that we had to deal with Mr. Keenan. So I'm not calling the two subpoenaed witnesses.
Okay.
They're off my list.
Okay, so tomorrow we have your one witness, and are there any other witnesses tomorrow? No. Then on Friday, how do we stand for Friday?
Your Honor, Frank Hughes will be in person testifying on Friday.
Who? Excuse me.
Frank Hughes, he was a former Massachusetts State Police employee.
Okay, so he'll be testifying.
He will.
Okay, so Mr. Burke, are you going to call any witnesses?
Well, it's kind of a joint.
Oh, okay.
It's kind of a joint witness
Okay.
that we're calling. So that would be it.
So on Friday, there's going to be that one witness. Are there going to be any other witnesses on Friday?
From the state police, no, I'm not sure about the other respondents, but respond to McKeon, it's just Frank.
Just that one witness, okay, Mr. Conley.
If it ends up fitting, I may call Chris Hodgins.
Okay.
Again, that would be possible. If so, I think it would go longer than necessary and will take us into the following week.
Okay, so let me just say, what witnesses remain? You know, are you gonna call your client? Have you made that decision yet?
Well, if I were making a decision today, I think we'd all move for directed verdict. But it is my intention to call Mr. Early. And if I'm calling Mr. Early, my intention would be to call him at the end with the one potential additional witness after that being me
You.
if it became necessary.
Okay, so, Mr. Burke, do you anticipate calling your client? And once again, I'm not gonna hold you to it, I just want to get a sense.
Obviously, Judge, we intend to call my client, however, she has some other issues that she has to attend to.
Okay.
And will not be here until potentially Thursday of next week, either Thursday or Friday.
Okay, well, anything I can do to accommodate the schedule of anybody, please let me know. Okay, so we'll see you then tomorrow, which would be a relatively short day, and then we'll keep it going on Friday. Okay, is that it? Have a nice day.
Oh, no.
That's not it.
Oh, no.
Oh, we're not even close. We're not, oh, no, we're gonna be here for a while, okay.
We have exhibits.
Okay.
To enter into the record, so I'm not sure how you'd like for us to do this.
Well, let me suggest this, and it's about 4:15 today, and it's been a long day. Tomorrow, it looks like it's gonna be a relatively short day, so might I suggest we do it tomorrow, realizing that now you're gonna have to tote that all the way back to your office and tote it back all the way tomorrow. But do you mind doing that so we can do it tomorrow?
I don't mind doing it tomorrow, I just wanna make sure we do it tomorrow.
Well, if you
because it's
remind me, yes.
really important.
I recognize that.
Okay.
Okay, is there anything else?
No, that would be it.
Have a great day, safe travels.
Thank you.
Okay, thank you.
Thank you.
Mr. Chair, what I plan to do is I am going to alert the student what I plan to participate in that film.
Yeah.
That way there, I'd hate to have everybody wait on me for something that I wasn't planning on
Sure.
listening to. So I'll try to communicate, but I'll need to know that.
Sure. I take it your client won't be here?
Correct, that's right.
Okay,
He will not be here outside of my presence.
safe travels, thank you. Thank you. Thank you, Madam Court